Ah, there we go. Carmi is a vampire. Carmi is a vampire. Or Nancy Grace. Carmi is a vampire. Or Nancy Grace. Carmi is a vampire. Or Nancy Grace. So. Hold on, let me pull up the chat. Carmi is a vampire. Or Nancy Grace. So. Here we go. So I don't know if this case is actually like known by anybody, but I had to learn it in law school, and I think it was on Halloween that they taught it, or the day before Halloween. So the Viva lawyer who got laid off, so he became a hot dog seller. That doesn't sound so bad. Thank you, Kels. Ooh, I better put my chat on. All chat, live chat. There we go. You can see from the side. Look at the eyes. So I pull up the PDF of the case now. Here we go. So this is not a criminal case, but it is a Halloween case. There we go. Okay, so this is the case of Stambovsky versus Ackley. What does it say? I'll be with you as soon as closing is done. Oh, is it the Alicia Andrews thing? Yes, there are poltergeists. Alicia Andrews, I think. Alicia Andrews, one or the other. Should I react to Kat reacting to the closing?
The killers didn't get him in October. The rifle that was used to shoot him, that shot that projectile, that shot him in the foot, a casing was recovered from that scene. The fact that that is connected to the homicide to kill the exact same
Take that, Kat.
victim is absolute evidence of intent. It is the most powerful type of evidence of intent that could possibly come before you.
Yes.
When we talk about
there we go.
her phone evidence, when we talk about what we have to show to prove that she had the knowledge and the requisite intent, that is why we brought that phone evidence to you. Because there's no doubt of what happened to this victim. There's absolutely no doubt of how he was stalked. And I think the defense attorney said and talked about Rashad Murphy and
the State
Davan
Prosecutor
Murphy
would wanna know.
about how they would not allow her to know what was going on. What I can make an argument about that and submit to you is that I do agree with that. There is no way that people who are going to commit first-degree premeditated murder would allow anybody into their inner circle unless they were absolutely trusted, that they absolutely trusted that person 100%, that that person is ride or die, because all of them can be identified if law enforcement finds out. And she absolutely proves that that's exactly what she is.
I do feel kind of silly watching a murder
Because when
trial in a
faced
shortcut
with law
fit. That seems kind of
enforcement,
inappropriate.
When faced with telling her that you could be charged, that you will be charged with first-degree premeditated murder, she would not give any of them up. She would not give a name. She would not give a description, because she did not want to implicate any of them. And when we talk about consciousness of guilt, that is evidence. Just like circumstantial evidence, all of that is considered evidence in a case. There's not going to be anything in these instructions that define for you what direct evidence is, what circumstantial evidence is, or what consciousness of guilt evidence is. But all of the evidence that is presented to you can be evaluated by you to determine whether or not the defendant is guilty or not guilty. And she is not innocent. The evidence in this case proves overwhelmingly that she lied to law enforcement. And that evading of law enforcement, that lying to them, shows that she has something to hide. Innocent people don't have to lie to law enforcement. Innocent people are cooperative and tell what they know when somebody has been
No, they're not.
killed and
Hey, Aaron.
killed in cold blood. And that is what has happened in this case. Charles Jones was hunted and he was tracked down and he was killed. And to suggest to you
Thank you, Rice Street, for all the
that
gifts.
she was not a trusted member of this group, of this conspiracy, flies in the face of all of
Yeah,
the
Aaron, I'm going to be
evidence.
covering
We rely
this.
on you to use your common
I'm
sense
getting
when
warm
you
in my outfit.
evaluate this evidence. And when you look at what is on
This
her
case
phone,
about poltergeists
and when
after
you see the personal
closing here.
animosity and what she was living in at the time when she wrote those
watching
messages.
Cat.
The one message that isn't
Ah.
in evidence, when I asked her about Antonio Tilley and the person who died the day before Charles Jones is shot in the foot. Remember that? I refreshed her recollection.
Well, you need to link it up to evidence we
Poltergeist.
did here, okay?
Help
You
him
heard
out.
her testimony. I questioned her on her conversations with Isaiah Chance, her co-defendant, her boyfriend, the person that she continues to protect again and again and again. I questioned her about the communication she specifically had with him in 2023, not 3 years before this homicide,
I don't know. Alicia Andrews did put
less than
makeup on
a
that one
year
time, so
before
she's
this
probably guilty.
homicide. And she claims she knows nothing about the gang stuff. She knows nothing that is going on. There is more than one conversation with her and Isaiah Chance about what is going on in this gang war and who has been killed, personal in their lives. One you saw in evidence, the town center, where it is clear they have talked about it before, because her response when she realized it's about the town center and that 23 has been killed there, she says, I forgot. I'm sorry, we don't have to go there. That conversation is in evidence. You also have testimony from her on the stand specifically about the death of her boyfriend's good friend,
Matthew.
Antonio Tilly,
I think she's doing
that
a good job.
occurred on October 6th, the
I have no
early
idea what she's
morning
talking about,
hours
though.
going into October 7th
Except for the part about innocent
of
people that have no reason to lie,
2023,
'cause
where I
they
specifically
frequently
asked
do.
her on the stand, you've talked to him about that. Oh, I can't really remember. So we refreshed her recollection. It's not an
If
evidence,
innocent
but
people
we
have no
refreshed
reason
her
to lie, then
recollection
why
with
do
the
cops do it?
conversation. All of a sudden, she remembers it, right? That's what she does. She doesn't remember it until she's faced with hard evidence. She
That's what
sees that
every
conversation, and
cop
now
that
she's
the
got to
state
answer
to the stand
questions
does.
about it,
Good
right?
point, Kat. Good point.
And what is it about? It is about another person close to her boyfriend that has died in this gang war. It's about Antonio Tilly. Tilly's death. He is upset about it. And before I can even get a question out, she says, oh, yep, he didn't want me to be around him at that moment. He was so upset, he didn't want me to be around. He needed
There's
to
actually an
be by
interesting thing
himself.
in this case that I was thinking about doing a video on.
And then there's another
I did do.
conversation
I remember this time.
on October 8th,
Or
the
live chat.
very next day,
All chat? Top chat? Yeah,
where
all
he
live
has
chat.
done something, and they have talked about it. And he needs her to be loyal. She remembers that, right? She would have you believe, now that we've
still in
confronted
the
her
chat,
with
too.
that evidence, that he wants her to be loyal, and that she needed to
Yeah, I have kind of a
delete
janky,
that conversation that they had texted about,
janky stream
that
setup
that's
right now 'cause I'm
about her
stealing
cheating
cats.
again. The same boyfriend that she has testified to you
Oh yeah, I was going to
about
say there's a
domestic
law in
violence,
California.
that she's
it's the same in
afraid
this
of
case
him.
too. Mute for a second. Where women couldn't enter evidence of domestic violence, or I really should. This is so unserious. Me talking with a shark outfit on about this issue. Women weren't allowed to submit evidence of coercion or domestic violence in murder cases. Oh, the vampire is barking and ripping my headphones out. Wait. Even if they had been coerced, and that was something that I went to USC Law, Southern California, and the Innocence Project there focused a lot on cases where women had been coerced into being parts of a criminal conspiracy. Women, I can't do this. Women who've been coerced into being part of a conspiracy, like a murder conspiracy, were kind of retroactively exonerated, or at least had their sentences commuted or reduced based on the fact that they'd been coerced. You're allowed to enter that evidence now, but for a long time you weren't. So there are cases where women would be like they were suffering from domestic violence, and maybe they were like forced to wait in the car while the boyfriend ran in to like rob a store and ended up killing somebody. Then came out and the woman was like there, maybe she drove away or something because he told her to. And they'd get like convicted of murder as either an accessory or conspiracy liability. And that was kind of the main thing that they worked on for a while, were cases like that. Because, it wasn't even really a conspiracy because they weren't agreeing to do it. But without the evidence of the domestic violence, it was hard to prove that they were, not willingly part of the murder or part of the crime.
Photographs from
I don't know if
her
that's the case
phone.
here, but I know they excluded
Nobody from the
domestic
state
violence
side
evidence.
ever suggested to you that she is a gang queen pin. Nobody has suggested to you through law enforcement, to any witness the state put up with law enforcement that is an expert in this gang war in Jacksonville. They have all said the same thing. She is not in a gang. She is not charged with being in a gang. Why is all of that relevant? Because, again, to law enforcement, she lied about it. She lied about knowing anything about the gang. She wants them to believe that she has no knowledge. She wants them to believe that she doesn't even know about her boyfriend's
GSC
nickname,
Grinding talks about this a
Gutta.
lot.
And you all know, again, the evidence is overwhelming that
your
that
closing
is
shouldn't be
a
longer than half an
lie.
hour, except in
Not only does she call
the
him
most
Gutta,
exceptional of
not only does she
circumstances, like maybe
know
YSL,
that that's
for
his
example.
nickname, not only does she know that is his gang stage name for his own drill rap videos.
But this part that she's on right now kind of gives
She
me
has
that
it
sense. I mean,
tattooed on her twice.
the jury
That's
heard
the
all this
reason
evidence.
why those photographs are relevant. It again shows her lying to law enforcement. The reason that you saw all of those messages to other people in the gang about the gangs, there's conversations about Bibby and Robert Howard, gang member after gang member. That corresponding message to Jewel Jordan.
yeah, exactly.
We brought that to you. That's a good friend of hers. You think she wanted to
It's on video,
testify
him getting shot
against
and
her
killed, but not her
friend?
there. Yeah.
You have to evaluate each and every piece of evidence and what it shows and what it proves. It proves that she knew exactly what was
Yeah,
going
that could
on
definitely
in
be
this
Darren.
gang war. It proves that she personally knew people that were affected by this gang war.
She knew people that were affected by the gang war. That's what you're going with?
I know that there is a lot in there. The defense attorney argued to you that there is no text messaging of her or Instagram of her from her phone. That is because she got rid of her phone. You heard from not only our expert, but their expert, some
Yeah,
of
I know,
this
Aaron.
information is not backed up. Some of this information you can only get if you have the device itself. That text messaging that we have between her phone and Sean Gathrigh's phone during the
It is
time
tricky
of the
because, like,
crime,
if she just
that
knew what
was
was going
only
on,
retrieved by
That's
Sean
not
Gathrigh's
enough.
phone.
Having knowledge of what was happening
Her
isn't enough.
phone didn't have
She could know
those same
everything that was
messages.
going on and it would be not guilty.
Her phone is backed up, and her phone had photographs on it. Her phone had conversations on it. But the time period, you heard from Detective Ramos, where they were looking at that time period for the crime was not on the Apple iCloud backup. And there's two ways that can happen.
Oh my God.
It can happen either by it not being something that she backs up, or it can happen if a person personally gets rid of that time period
She had
and
to get new phones
deletes it
multiple times.
from their phone.
That is a crappy boyfriend.
We never got her phone. You heard that others got rid of their phone. Sean Gathright, who was using his phone in this instance. So it wasn't just her that got rid of her phone. Sean Gathright got rid of his phone as well. And again, more evidence of her intent is the conversation when she knows law enforcement is looking for her. That's why we presented all of that information from the phones to all of you. Because again, it is evidence of her intent that something is on her phone that she does not want law enforcement to know about.
That's also.
That is the reason she's laughing her, LMFAO. That is why she is laughing out loud, because
like
law
this.
enforcement got her new phone. And in the middle of this search warrant, when law enforcement is executing it, she has a new phone that she is trying to back up all the stuff from the iCloud. She got
she
rid
could
of her
know everything
device,
that happened
and
in
she
advance.
got rid of the specific text messages
And she could be happy that it
that
happened.
surround that
Still not
time
enough.
period. If you look at those videos where her boyfriend, Isaiah Chance, is walking around with her phone, it's not just up to her ear. Look at it. He has it out like this. That is when a
Her text
way
actually-
a person holds a phone when they are speaking on speakerphone.
What generation
there
is she?
are
What
conversations
generation is this?
happening.
Generation Alpha?
And there are
I know what
calls
generation
that
we're
are
on now.
being made and communicated between him and the shooters.
This is a
vehicle.
rebuttal? This isn't even the. Oh my goodness.
And they keep on suggesting to you that the
that
call,
makes
the
sense.
attempted call
I've got
that is in the
recorded.
call detail records happened when he is out in that parking lot in Teasers.
Who did the
That is not, if
closing,
you
the
look
first
at
one?
the
Was it
timing.
the dude again?
Both by our
guy from
expert
the
and the
opening?
defense expert, The timing is clear. That's why we went through so much trouble about making sure the timestamp is accurate at each and every video that you heard. And when you look at the call detail records, the calls that are reflected on the call detail records of her phone show that she is already in her car with the defendant when those calls are being made.
That's still not enough,
What
though.
is not captured, what is an unauthorized app that they are using when she needs to put in her passcode, is not captured because they are using another app to make those phone calls.
What?
Yes?
Another sidebar.
Is that not an evidence?
We got
or
a
something?
sidebar during rebuttal. I've seen a lot of objections and openings and statements at this point. I don't even think it's that rare anymore. But sidebars, this has been a lot of sidebars. Get him, Arian. In the meantime, huge shout out to like a ton of gifted memberships have rained down on the chat. We had J Money drop 5. We had Rice Street drop 5.
It seems like they're having a hard
Thinking
time
back there like, let's make it rain in here.
getting beyond knowledge. Like, knowledge is a part of the conspiracy. You need to know what was going on, but you need to do something in furtherance of the conspiracy. And it seems like they're just talking about the fact that she knew it was there and knew it was going on and was happy it happened. That she was intimately, involved with the trip and what happened, but actually furthering it seems
with
tricky.
the vehicle that has the assault team in it. And that is not something that they want tracked. The other piece of evidence that is in
Because I don't believe she was ever in a car by herself when she was scouting the location.
enter her passcode. Her phone is protected. She has a passcode that she has to put in there, and that is something that happens automatically. Anybody who has an iPhone that has a password or has to get into their phone by their
she doesn't
face
drive.
knows
Yeah,
that
that's-
is something
that's
that
tricky.
happens automatically.
I think it's legitimately, Haley, I do think it's like a legitimately difficult thing to prove. The actual act in furtherance.
And
Oh, wait, she did book the Airbnb there, right?
use her phone, and when it
That
goes
could be
dark,
enough.
she has to put in the passcode for him. She knows what is being said on that phone to that second vehicle.
That's not enough.
There is no way
That's not enough.
that she did not hear what was going on.
Doesn't matter.
There is no way that she did not know everything that was planned to occur in Tampa. This whole story about teasers, and now to make it, I guess that she didn't lie to law enforcement this one time about the bouncers, they're saying that was about that was about the Players Club. That makes it even a worse story.
Yeah,
Because
we're just,
now it isn't that she didn't
I'm
get to
stealing
go
Pat's
to
string,
2 clubs.
and then I'm
now
gonna
it's
cover-
that she didn't get to go to 3 clubs. All 3 clubs were either too packed,
Poltergeist
overpriced.
case.
Is it it's too packed based on the
said
parking
it's supposed
lot
to be a makeup
and the
weekend.
amount of cars in the parking lot? If that were really the truth, then they never would have had.
I believe the crappy boyfriend defense.
But again, that crime is on video. And the only time they get out of their vehicle, that is to see if the victim is at that location, at Teasers, at Truth 18. That is why they are there. The defense attorney talked to you a little bit about the jury instructions. He talked about murder
Yeah,
in the
I think
second
about that.
degree.
See,
And so I
could
just wanted
believe
to
a
touch
crappy
briefly
boyfriend
upon it.
doing that.
There is another instruction that you will hear from the judge, and that is that you should find the defendant guilty of the highest crime that has been proven beyond and to the exclusion of all reasonable doubt. And the top count for count 1 is first-degree premeditated murder. And principle applies to this. Principle also applies to murder in the second degree. But this case, murder in the first degree,
They could make the font a little smaller.
is the
Interesting
top
they grew up in this
count,
neighborhood in
and
Tampa.
all of these elements
really?
have been
That's crazy.
proven at beyond and to the exclusion of all reasonable doubt.
I've only been to
And
Tampa
the
once or
reason
twice.
why I'm putting this back up is because the death count 2, if you look at element 2, count 1, the death was caused by the criminal act of Alicia Andrews. That always is going to be read in a principal case. She is never alleged to have touched a gun. She is never alleged to have been one of the shooters. She is guilty as a principal. And
I don't think you would
because
like the
she is a
defense PowerPoint.
principal,
Oh,
you
boy.
have to put her
We need to
and
have like
treat
a
her
CLE.
as
or, like,
if
a
she had
continuing
done all the
education
things
for,
the other person or
for font
persons did
choices.
if the state proved beyond a reasonable doubt she intended the crime to occur and that she did some act or said something that was intended to and did assist the other person
it seems
or
like the
persons
second
to
part
actually
is
commit the
part.
crime. That is read in conjunction with murder in the first degree, which this is a murder
Background
in
is
the
a pickup
first
courtroom
degree.
with black. Oh my goodness.
This is the highest
That's
crime,
bad.
the top count that has been proven in this case. The second,
wait, YP, let me check.
the lesser to murder in the first degree is murder in the second degree. The principal instruction also applies to this. So when the defense attorney is up there arguing to you that Charles Jones is dead, obviously that has been proven beyond
This is
a
Carney
reasonable
in his Nancy
doubt.
Grace costume.
The death was caused by the criminal act of Alicia
I missed
Andrews.
the defense closing. Maybe I'll watch closing.
That the principal instruction also applies to that. So if you find that a lesser has been included, you don't say that she's not guilty just because she's not the person that committed the criminal act. The principal instruction applies to that. If you're looking at murder too,
I
that
have
there
no
was
idea
an
why this is being done
unlawful
on
killing of
rebuttal.
a victim by act imminently dangerous to another and demonstrating a depraved mind without regard for human life, and then it describes what the act includes. It also says in order to convict of second-degree murder, it's a distinction for first-degree murder. It is not necessary for the state to prove the defendant had any intent to cause death, but she can still be convicted as a principal. What separates second-degree murder from first-degree murder
Watch the
is
defendant's testimony.
premeditation.
Oh, she took the stand?
Premeditation, we've already gone over what that means.
How is this
And in
possible?
this
I'm
case,
stealing her
there
string.
was
I
premeditation.
told her.
There was planning, there
Yeah, it's
was
too hot.
getting weapons. All of that is a conscious intent, a reflection for a homicide to be committed. And that's what separates first degree from second degree murder. And with the judge's instructions, you will hear that you should find the defendant guilty for the highest count that has been proven beyond and to the exclusion of all reasonable doubt. And in this case, when you hunt and you stalk a victim in order to kill him, that is first degree premeditated murder. The defendant argued in his case that the defendant was cooperative and truthful to law enforcement. You heard all of that evidence,
This is
and we
ineffective.
argue and
This is a bad
submit to you that she may have said one or two truthful things, but the majority of what she told law enforcement was not true.
The jury
You
knows
will
whether she
see
was or not.
all
They've
of
already decided
the
that.
messaging
Also
on
funny,
the
there's this one
phone.
guy in the
You will see
background.
the conversations that she
Looking for
had
us.
with all of her friends. You saw the photographs.
This guy.
And here's another one, again, from her Apple iCloud that has been put into evidence, state 75C3, was not published, but we asked
I'll
her
cover for Kat.
specifically about Kay Shorty.
There we go.
Another person in one of those photographs that you saw where that person is throwing gang signs. I'm not going to read all of it to you,
What is this? Matthew, this is what
but
I'm
she's
talking- this
having
is-
a talk with him.
What is this?
And again, it is about more and more gang stuff. She is having a conversation with him.
What in the name?
And if you look at this, it goes more and more about the death of Bibby.
It's okay, Kat,
and
I'm
why
covering for
he
you.
is so
You can take your time
torn
getting
up
this.
about it. So this is state
Oh, wait, Carmen.
75C3.
Kat.
Another person that we showed you a photograph that she is friends with that is in her phone.
It's a vampire.
So look at all of the phone stuff and see that what she is saying when she suggests to you that she doesn't know what is going on simply
Actually,
is.
I want to read that text again. Okay. Well, what did she say? That you don't need to be talking to me? Because, to be honest, I never used to be how I am. I mean, I always used to carry guns since 13 years old, but I just like them. Then I started selling weed because I never had nothing. My mama had 5 kids, so I could never get what I wanted. So I found others to make money. When I got in 9th grade, I even tried selling snacks at school. And I was making money until everybody wanted to do it, so I went back to weed. True. Then I got in an incident where I shot somebody and got charged with my homeboy armed robbery charge, but I only got 2 years because I was 16, and that was my first time ever going to jail when I was locked up on 3 people who wrote me. And that was K-Block Bibby and my dog named Cap K-Block. Never missed no visitation. Sent me pictures, but the rest of them I didn't hear from. I told myself I wasn't going to hang around nobody but them, and I was going to come home chilling. Then Bibby died 4 days before my birthday. That shit broke me. He was my main man. I took him in. He didn't have shit. Like me, but together we always made shit happen. I tried to tell him to stop running behind Fulio, because that ain't your crowd. He said he was, but he died the same week. I came home, got a job, was doing the right thing. I had graduated and all, because I knew it was finna be in the streets late. I don't know how this is supposed to be incriminating.
5C3. Another person
I
that
also
we
don't know
showed
why
you a
this would be,
photograph that she is friends with that is in
rebuttal.
her
Like, I don't really
phone.
get the point.
So look at all of the
It
phone
is.
stuff
It's not
and
Nancy Grace.
see that what she is saying when she suggests to you that she doesn't know what is going on simply is not true. She's not using a first name like Tom or Jeff. These conversations aren't about somebody named Ryan killed in this gang war. You're going to see names like Bibby, such of a that even names because that test they have not offered her any protection. Why does she need it?
I mean,
She
I
didn't
talk a
know
lot of trash
anything
and push some
happened.
ethical bombs.
That's what she's telling
I mean,
you.
I don't, but
She
you know.
didn't know anything, any crime
might
had
be too far.
occurred. She didn't know Davion Murphy, doesn't know that he's connected to a gang, even though he's related to the person who was killed at Rains High School when she went there. She doesn't know that
This
Rashad
isn't
Murphy
very
is
good.
in a gang. She don't know him. She don't know them. I don't know those people, right? And in the same breath, she is saying that nobody offered her protection. Did she look afraid in that interview? Did she look scared talking to law enforcement? Did she look intimidated talking to law enforcement? Or was she laughing? Was she bored? Was she
Those
annoyed?
people never laugh when they're scared.
All of the evidence in this case show that the victim in this case was killed. All of the evidence in this case shows that the way that he was killed is first-degree premeditated murder. And the way it was done, it was planned, it was premeditated, and none of that can be done unless everybody talked about it and planned it and conspired together to do it. Based on all of the evidence in this case,
The shark.
we are confident that you will find her
glad to hear
guilty
that.
of first-degree premeditated
I'm
murder
getting too warm.
and guilty
so
of
I have to
conspiracy
periodically
to
take the
commit first-degree
cap off.
premeditated murder.
Over.
All right, thank you. All right, members of the jury, I'm going to pick back up with the jury instructions where we left off, okay?
Oh boy. 60 seconds, all caps in the chat, guys.
The defendant said he is not guilty. This means
Let
we
it
must
out.
presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced
Chat
doubt.
is saying,
Such a doubt must not
hey, Dina.
influence
Thank
you
you for
to
that. Thank
return
you
a
so
verdict
much.
of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing
I can
all
do
of
a
the
rewatch of
evidence,
some of
there
this
is
stuff.
not
I
an
was kind of
abiding conviction of guilt,
busy last
or
week,
if
too.
having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with
Consider
the
how the
other
judge acted.
testimony and other evidence in the case? 6, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 8, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for the lawyers to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to the lawyers about his or her testimony. You may rely upon your own conclusion about the credibility of any
Thanksgiving
witness.
trials.
A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of
Need more
court has been
Halloween
placed
trials.
before you. Such a statement should always be considered with caution and
feel
be
like with the way
weighed with
prank
great
videos are
care
going,
to
we're
make
probably
certain it was
April-themed-
freely and voluntarily
April
made.
Fool's Day theme trial.
Therefore,
before too
you
long.
must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the
This is
defendant's
still
out-of-court
live.
statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you
Man,
to
her
make
voice
a
got louder
wise
there.
and legal decision
No
in this
nullification.
matter. 2, this case must be decided only upon the evidence
really
that you have
emphasized
heard from the testimony of
She
the
really seems to
witnesses
wanna
and if
get
seen in the
guilty
form
verdict
of the exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this
Doesn't feel like
case. 5, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 6, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions.
Did she say?
Deciding a
don't be
verdict is
sympathetic twice?
exclusively your job.
Ask
I
rhetorically.
cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable
I
doubt.
agree, and I think people are
If you
too-
find that
too
no
soon to tell
offense
judge by
has been proven beyond
Too
a
quick to
reasonable
tell judge
doubt, then
bias.
of course, your verdict must be not guilty. The verdict must be unanimous, that is, all
like
of
every-
you
it's like
must
every
agree to
case.
the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. In the Circuit Court of the 13th Judicial Circuit of the State of Florida and in for Hillsborough County Criminal Justice Division, State of Florida versus Alicia Latoya Andrews, case number 24 CF 11996, Trial Division 1, verdict form. We, the jury, find as follows as to count 1. Check only A, B, C, or D. A, the defendant is guilty of first-degree
I thought
murder
this
as
would've been better
charged.
to do on
B,
Monday.
the defendant is guilty of second-degree murder, a lesser-included offense. C, the defendant is
Like you read
guilty
the
of
instructions, then you just
manslaughter,
go
a
and
lesser-included offense. D, the
I'll say
defendant is
second-degree
not guilty. We, the jury, find as follows as to count 2. Check only A or B. A, the defendant is guilty of conspiracy to commit first-degree murder as charged. B, the defendant is not guilty. So say we all, dated this blank day of October 2025, and then there's a signature line for the foreperson of the jury to sign and print their name. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's
see that.
job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in the case, you must tell me by giving a note to the court deputy.
Did they record the juror?
Many
No.
of you may have cell phones, tablets,
Okay.
laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items are received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Okay, a couple of things. Number one, we discussed this during jury selection, but just to affirm it here.
It is
All of your
6:45.
information is confidential and under seal.
Oh, wait, I'm
Okay?
responding to the wrong
Nobody
chat again.
has access to any of your information. Your identities have not been disclosed through the media or otherwise. From this moment forward, I will only refer to you by your initials and your juror number. Also, the foreperson of the
Yeah.
jury who signs the verdict form and prints the
There's
name.
names there.
When the verdict form is read, I will only identify the foreperson by the initials and the juror number. The signature and name of the foreperson of the jury will be redacted from the verdict form. It will not become public record. Additionally, it is late. I concede it is late. However, whatever time you all reach a verdict, there are sufficient law enforcement personnel to escort you safely to your car, so you don't need to worry about that at all. Okay, a couple of things. So, juror number 77, initials BS.
They're staying.
You are our alternate, okay? So you're not going to be participating in the final verdict. So this is what's going to happen.
If you held
Do
me
any
all
of you
day.
have electronic devices on you right now? Okay, if you do, that includes smart watches, okay? Anything that's got internet connectivity, because you can't have that in the jury room.
We're going
Leave
all
those
night,
in your
chat.
seat. Our alternate, juror number 77, do you have
Yep,
anything
this
in the
is
jury
live.
room? Okay, so what's going to happen is, you guys are
crazy.
going to go back to the jury room as a group. The bailiff is going to collect any electronic devices from the 12 remaining jurors. Juror number 77, grab whatever belongings you have, step out. I'm going to talk to you a little bit further. And just so you all know, you cannot begin deliberating until everyone has cleared the jury room. Okay, that includes law enforcement personnel and the alternate. Once it's just the 12 of you, then you can begin deliberating. You're going to be sent back all of the evidence in this case, and do we have a laptop or something that they can?
Yes, Your Honor.
Okay, so you'll be sent a laptop. If you want to review any of the digital evidence, you can use the laptop, but there is no internet connectivity, okay? And there was one more thing. Oh, I know. In the pack of jury instructions, those are your jury instructions for each of you to use. However, there is a copy of the verdict form. The bailiff will send back the official verdict form. All right, so the one that he gives you all is the one the foreperson needs to sign and date when you will have reached a verdict. Okay, very good. And I think he's going to talk to you about ordering food. So you have that to look forward to. All right?
They get food.
Okay, very good. Our alternate juror, please collect your things and step back out. All right?
Do a verdict watch, just
All
watch.
rise.
That's the plan.
I don't know, so
You just text the family that they're going back or?
Yeah, that's fine. Do me a favor. If you need to notify a family member, do it now while the law enforcement's in there with you, and then turn over your electronic device. And also, if anybody needs to reach you in an emergency, we have your devices, so, but you can do that before you begin deliberations, okay? All right, thank you.
Jeez. Oh, man.
Clock starts now, I guess.
If they want to come to a quicker decision, maybe that's good for the defendant. I don't think that worked well for Ashley Benefield in the Black Swan murder trial.
If we wanted to give
I don't know
the
that one,
defense and
Black
ask
Swan.
permission, if we
I've
have
heard of it.
the exhibits
guessing
that are
it was
on
about
video
murder somebody?
downloaded to the, there were some issues with the disc skipping. I don't know if defense has an objection, but they can look at all of
I
this
did about
stuff.
it against her one time. She was
If not, we
insane.
can take it all off. Just of the video exhibits.
So I'm sorry, what are you asking me?
Somebody.
If that can remain on
Interesting-ish.
the computer that goes back, or if not, we can delete it.
Okay,
But some
well,
of the
Why did she have a
discs
plastic
were not,
cup?
Right.
were skipping, so if
My mic is
defense
low?
wants to look at it and see that they're just the exact replica of the disc,
Okay.
But, or.
Is that better?
If they have an objection to that. The ones that are on video.
Okay, stop, hold on, stop. All right, come on up, come on up. Okay. So I'm not gonna keep you here any longer. I just want
There
you
we
to know
go.
how much we all appreciate your willingness to serve. You may be elated that you're not participating in the final verdict. You may be incredibly disappointed. We have to have 12 members of our community agree to serve on these juries. As you can see, a lot goes into these trials. And if one of the other jurors had gotten sick or had a family emergency and had to drop out, I would have to declare a mistrial. We have to start all over again. So I sincerely hope that you don't feel your time was wasted. We are indebted to you. All of us are indebted to you so very much. So with that, you're now free to talk to anybody that you would like about this case. You're free to stick around. You're free to run out of here as quickly as you can, whatever you wish to do. And on behalf of everyone involved, again, thank you so very, very much.
I think
Okay,
it's what?
thank
It's almost
you.
7 there, right?
I don't know. I mean, they're getting food, so I would imagine they're gonna at least wait and stay for the food.
Okay, very good. So I guess you guys can just talk about the
Don't
Thank
think-
you, Moses, for the
this
super.
issue.
I guess so. I don't know
Um,
how the timing's like
Madam
there.
Clerk, do you have all of the evidence?
Germ misconduct.
Okay.
Oh, yeah.
Okay,
We have some at the
True.
table already.
okay, so just make sure Madam Clerk has everything for the,
I think they need to restart deliberating if there's a juror, though. So
and Reggie, can you?
you have to restart deliberations entirely. That'd probably be okay.
I will, if there is a verdict tonight, I do want to come back on. I feel like we could just like put up an idle screen and leave this on if you guys want to chat. If they have to get out of there by 10, if they have to close the court by 10, that's what Mountain Man is suggesting.
Yeah, those kids aren't going trick or treating.
That would be fine. I think there's like worries with YouTube that if you go longer than 12 hours, there's issues when the stream tries to get published after. But that would keep us under 12 hours on this. And I don't know, I can't predict if there's going to be a verdict today or not. But I feel like this is kind of a rush situation. And if you've got 12 jurors that are willing to just put their decision on paper and get out of there, there could be a verdict today. I don't know. Yeah, in the meantime, we have, like something happens at 12. Like one of the YSL trial days, we like ran out of here. Like it was like counting down to the exact 12-hour mark, and we ended the stream like seconds before. But I've just heard other creators say that there's issues with saving the live stream as like a video on demand after the fact.
Yeah.
If you exceed a certain time point. So don't want to do that. Mavka says, you can ask me for legal opinions if you want the correct take on everything. I do want to get through some of the chats and conversations, and I don't know, put your thoughts in the chat if you want to like leave this up for some discussion. But I personally, even though I'll come back for a verdict, I'm personally going to hop around. I've been wanting to see what Jim's talking about, and I think his chat could see us right now. So, hey, he's doing
What's up, Kat?
haunted
We're gonna
house
pretend that she can hear
themed
me.
stream for the holiday. So I want to go check that out.
Thank you,
And
Kat.
if we don't leave this up and running, I'll fire up and jump back on if there's a verdict tonight. So either way. Well, also, let's do this poll, guys. So
Me
if
too.
you want to participate in the
Sometimes
final
even I don't know
poll
what I'm
of the
talking about.
stream, really what you think, how you would vote if you were on the jury, get your vote in. We'll let that run for a few minutes, then we'll close it out.
All
Metalcore, thank you for becoming a member. Thanks for turning
Okay.
green. So happy to have you. Love the picture. Always love.
I'm going to leave Kat's stream up in the background, so if something does happen in the case, then I'll know about it. And then you guys will know about it. And Let me see here. While I'm waiting... Ooh, let me put this... Mm-hmm. There we go, that's better. I messed everything up to make my thing look like cat stream. Okay. That's close enough. Hey, Mary. So I'm going to do a haunted house stream, but before I do that, I just want to show this one thing, because we were just watching the Alicia Andrews case. I got my shark outfit. We were watching the Alicia Andrews case, and it is a Friday evening, so I wanted to show a Friday evening case that bothered me recently. There we go. Yeah, it's getting really warm when I leave my thing on. Anyway, this is a Supreme Court appeal of a murder case from, let me see, 2014, so almost 12 years ago. And we don't need to know all this stuff. The victim was named Kat, not Williams. But I've read this part before, but this part drives me crazy. Oh, wait, not this part. Although I have read that before. 2. The trial court committed reversible error by not following proper procedure. Not that part. Not allowing jurors to rehear evidence upon request of the jury. But not Kat. No, exactly. So I'm just going to read like a couple paragraphs of this. This is the appellant's brief. This is, the defendant's name is Devin Grant. In the case of Barr, the jury sent a request to rehear witness testimony. That would mean the court reporter would read it back. When jurors send a question out during deliberations, there are certain requirements that have to be met by the trial court. We're not really worried about that part. The trial court did not comply with the requirements for jury communications. The requirement that the communications must be in writing may have been complied with, but there are no exhibits. You're supposed to attach the written communications as an exhibit to like the transcript or something like that. Basically, it just needs to be in the record. The trial court actually states, now they have asked for somebody else, and so the answer is no. It's 4:15, and I'm not going to go into more. They want Scott Harrell's testimony too. I'm not doing it. I'm not opening it back up. They're just going to have to remember it. I mean, we can piecemeal this thing until we go back over the entire trial. I'm not doing it. I don't even mind sometimes doing 2. But I refuse to go back over all this stuff again. Trial court did not allow for the replay of the testimony because she stated, it's Friday afternoon. I'm not doing it. The court did not have the communication marked as a court exhibit. That was the request from the jury to rehear testimony, just to have the court reporter read back some of the testimony. Harrell was one of the witnesses. If you don't want to do the job, don't... Yeah, well, funny story. The court did not have the communication marked as an exhibit. Counsel was not given a full opportunity to respond, and when the jury asked to hear the testimony of Scott Harrell, the court gave no opportunity for a response. The trial court did not grant the jury's request, and the only specific finding the trial court enumerated was because it was late on a Friday afternoon. The trial court did not comply with any of the requirements when juries communicate during deliberations, and the defendant is entitled to a new trial because of the court's noncompliance. The record shows that when the court declined to let them rehear the testimony, the jury reached a verdict 20 minutes later. The trial court said, I'll give them 30 more minutes. They want 30 minutes, that probably do it. So they weren't allowed to hear rehear the testimony, and so they decided to just acquit, which doesn't really make sense, because if you're not sure and you want to hear something more, usually that means you do have a doubt. So I don't know how not hearing something again can result in a verdict 20 minutes later. It was also error for the trial court to refuse the jury's request to rehear the testimony of key witnesses. Citing a case, well, that case is distinguished because in the present case, the court did not comment on the veracity of the testimony. The jury only requested the replay of the testimony of Talia Thomas and Scott Harrell, who were key witnesses. Ms. Thomas purportedly testified about Mr. Grant's role. Mr. Harrell's testimony was critical in the impeachment of a key witness for the state. The court also seemed to contradict its own assertion that it would be willing to let the jury hear the testimony of two witnesses. I don't even mind sometimes doing two, but I refuse to go back over all this stuff again, when the jury, in fact, only asked to rehear Ms. Thomas and Mr. Harrell. These witnesses were key witnesses in the case, and the court committed error by not letting the jury rehear the testimony of those two. Aaron said, if you don't want to do the job, don't run for the job, which I agree with. Funny thing, she doesn't have to worry about that anymore. I wasn't going to read this, but that comment kind of made me want to. Pursuant to Rule 4E of the Rules of the Judicial Qualifications Commission and Superior Court Judge Williams, they stipulated to the following. Williams has retired from her position as judge of the Superior Court of the Brunswick Judicial Circuit. Did they vote guilty in this case? Yeah, they did. He's still in prison. The retirement from the Superior Court is effective January 2nd, 2012, and was submitted to Governor Deal on December 19th, 2011. I can't remember the trial date, but it was pretty close to that. The trial was middle of 2009. Williams will not seek, request, or accept elected or appointed judicial office in the future. The prohibition commences immediately and carries forward permanently. So she doesn't need to worry about running again. Let me see. Williams will not seek, request, or accept senior judge status for any court. And you see here, different signatures of stipulation. Resignation letter. 21 years of service. Makes you wonder. Well, actually, I don't need to wonder. I guess I can just show you. I mentioned this on my last stream, actually. There was a podcast. Open this up real quick. To show you, in case you're interested in listening. Where are you? Here it is. So NPR did, I believe, 2 episodes. Oh, this has 1 episode on this judge. Many listeners have written to us since our episode about Judge Williams, asking whatever happened to her. Did she face any consequences? And they're detailing the fact. The Georgia's Judicial Qualifications Commission filed formal charges against her. The 12 counts include a number of things reported on our episode. Sending away inmates for indefinite detention, jailing Charlie McCullough for 14 days for exercising his right to contest a drug screen. He actually won the second drug screen, by the way. He tested negative, but she said that she only cared about the first one. So even though he actually tested negative for drugs on the retest, which was like taken immediately after, it was like an A and B sample situation, she was mad at him for proving that he didn't do drugs and using rude, abusive, or insulting language with individuals appearing before her. They accused Judge Williams of sending Lindsay Dills into solitary confinement for an indefinite period without the ability to consult with a lawyer, despite the fact that the court knew her history of suicide attempts. She later attempted suicide while in solitary confinement. It accused Judge Williams of issuing this order from her chambers without the public or a court reporter present. Should have done a third test. Yeah. Judge Williams told the counsel that she had not issued this order, but the investigators apparently found a recording of her returning to her courtroom and declaring on Lindsay Dills she is not to have any telephone privileges and no one is to contact or visit her except the drug court counselor. Nobody, total restriction. Oh, here we go. I didn't have this saved. It's the same one. Oh yeah, I think I've read this on stream before, actually. But yeah, it's 31 pages long. And this was the judge, and she was removed just a few years later from the bench. But that did not affect this case here. And he remains in prison to this day. So on a lighter note, we are going to take a look. I almost said zombies, but it's not zombies, it's poltergeists. This is a case. Yeah, it is wrong. The prosecutor is actually being he's being sued by he's a DA now, and he's being sued by a couple of different counties for I think for misappropriation of funds or something. And then the DA was also removed, Jackie Johnson, removed from office. And then his habeas judge is a senior judge. And he held the habeas hearing, and then he just forgot about it for 7 years because he was like 90. And he just never ruled. So Devin waited 7 years for somebody just to make a ruling after the habeas. And a different judge actually entered the ruling because that judge had died. And you're not allowed to do that. It has to be the judge that has the hearing. So, essentially every step of his proceeding was, yeah, it is. Essentially every step has been just completely messed up. Now, on a lighter note, we are going to get into the poltergeists. This is Stambovsky versus Ackley. And 3 strikes, you're not guilty. What happens if the judge dies? I think you can, I don't know if you have to refile or like have a new hearing. It's just, I don't think it's really come up before. Because usually the part that takes a long time is like getting to the hearing. But like once you have the hearing, there's not a whole lot to there's not a whole lot to do. The judge just needs to decide. But I'm sure there's a case somewhere where it's happened, but I couldn't find anything. But you can just have like a new hearing because you have everything in writing, then just a day of hearings or something. Let me see. So this is a case. I read this case my first year of law school. I think it's first semester actually, in property law, and it involves a house that is haunted as a matter of law. Just have someone who looks a lot. They actually kind of did something like that, Aaron. They kind of didn't acknowledge the fact that that you have to have the right judge make the order, and they kind of like hand waved that requirement away. They like semi acknowledged the fact that it was the wrong judge, but not really. Okay, so this opinion here is all about the puns. You're going to see that there are many. And I love it. I love puns. I've heard of this. Yeah, it is Nyack. Plaintiff, to his horror, discovered that the house he had recently contracted to purchase was widely reputed to be possessed by poltergeists. There's some nice alliteration there. Plaintiff, purchase, reputed, possessed, poltergeist. Plaintiff, to his horror, discovered the house he had recently contracted to purchase was widely reputed to be possessed by poltergeists, reportedly seen by defendant's seller and members of her family on numerous occasions over the last 9 years. Plaintiff promptly commenced this action, seeking rescission of the contract of sale. That means you just undo it. Local lore that we have an official haunted. It's true. Supreme Court reluctantly dismissed the complaint, holding that the plaintiff had no remedy at law in this jurisdiction. The unusual facts of this case, as disclosed by the record, clearly warrant a grant of equitable relief to the buyer, who, as a resident of New York City, cannot be expected to have any familiarity with the folklore of the village of Nyack. Not being a local, plaintiff could not readily learn that the home he had contracted to purchase is haunted. Whether the source of these spectral apparitions seen by defendant's seller are parapsychic or psychogenic, having reported their presence in both a national publication and the local press, defendant is estopped to deny their existence, and as a matter of law, the house is haunted. So what that means is the court isn't saying that it's literally haunted. They're saying that because the seller has said all these times before that the house is haunted in multiple publications, she can't now turn around and be like, oh no, it's not really haunted. So the court has to treat it as if it is haunted. Easier to sell haunted houses. Yeah, exactly. So now the court's in the funny situation where they have to treat the house like it's actually haunted. So for the purposes of this court case, like, there are actually poltergeists in the house because the defendant said there were, which is kind of funny. More to the point, however, no divination. Oh, my mouse is freaking out. No divination, another pun, is required to conclude that it is defendant's promotional efforts in publicizing her close encounters with these spirits which fostered the home's reputation in the community. In 1989, the house was included in a 5-home walking tour of Nyack and described in a November 27th newspaper article as a riverfront Victorian with ghost. He did this 9 years after buying it. What is the timeline? This is 91. When did he buy it? I'm not sure when it was sold. The impact of the reputation thus created goes to the very essence of the bargain between the parties, greatly impairing both the value of the property and its potential for resale. I think that's the more relevant portion. Is my mouse is messing up. That's irritating. So you might not care that you might not even think it's haunted, but it could diminish resale value if that's its reputation. Even if it's, it is what it is. The extent of this impairment may be presumed for the purpose of reviewing the disposition of this motion and to dismiss the cause of action for rescission. While I agree with the Supreme Court that the real estate broker and agent for the seller is under no duty to disclose to a potential buyer the phantasmal reputation of the premises, and that in his pursuit of a legal remedy for fraudulent misrepresentation against the seller, plaintiff hasn't a ghost of a chance. I am nevertheless moved by the spirit of equity to allow the buyer to seek rescission of the contract of sale and recovery of his down payment. New York law fails to recognize any remedy for damages incurred as a result of the seller's mere silence, applying instead the strict rule of caveat emptor. Therefore, the theoretical basis for granting relief, even under the extraordinary facts of this case, is elusive, if not ephemeral. Hey, what's up? Yeah, I gather that it's been a long day. How long have they been going now? 10 hours? Pity me not, but lend thy serious hearing to what I shall unfold. That is the ghost from Hamlet. From the perspective of a person in the position of plaintiff herein, a very practical problem arises with respect to the discovery of a paranormal phenomenon. Who you gonna call, as the title to the movie Ghostbusters asks? Applying the strict rule of caveat emptor to I gotta add that to my pun list. Applying the strict rule of caveat emptor to a contract involving a house possessed by poltergeists conjures up visions of a psychic or medium routinely accompanying the structural engineer and Terminix man on an inspection of every home subject to a contract of sale. It pretends that the prudent attorney will establish an escrow account, lest the subject of the transaction comes back to haunt him and his client, or pray that his malpractice insurance coverage extends to supernatural disasters. In the interest of avoiding such untenable consequences, the notion that a haunting is a condition which can and should be ascertained upon reasonable inspection of the premises is a hobgoblin, which should be exorcised from the body of legal precedent and laid quietly to rest. This gets to a general law and economics theory about whether how much the owner of a house has to disclose. And it's kind of a balancing act because on one hand, the owner of the house knows the most about the house. So it's more efficient for them to just tell everything. But on the other hand, the owner of the house isn't going to know what the buyer, wants the house for, or what they value in the house, and what things are important, what things aren't important. So, that's kind of the opposing theory. So it's just trying to balance those two things: the fact that the seller has more knowledge, and the fact that the buyer has more knowledge about their preferences. And so state law is usually trying to balance those two things between, buyer beware versus strict disclosure. In most states now, you have specific categories of information you have to disclose, and as long as you do that, you're in the clear. Sometimes it's if somebody's been murdered in the house, you have to disclose that, or deaths in the house, any kind of structural things. But it depends. So that is what this case is about, disclosure. So it's kind of a dry topic made fun. It has been suggested by a leading authority. My apartment is a home that was built in 1862, middle of the Civil War. I'm sure plenty of people have died in this. Yeah. It has been suggested by a leading authority that the ancient rule which holds that the mere non-disclosure does not constitute actionable misrepresentation finds proper application in cases where the fact undisclosed is patent or obvious, or the plaintiff has equal opportunities for obtaining information which he may be expected to utilize, or the defendant has no reason to think that he is acting under any misapprehension. That's Prosser. It's a secondary source that you'll see a lot in cases from the 90s and before. So basically, if the house is an ugly color and you don't tell the buyer that the house is an ugly color, you're in the clear because they should be able to figure that out. However, with respect to transactions in real estate, New York adheres to the doctrine of caveat emptor and imposes no duty on the vendor to disclose any information concerning the premises unless there is a confidential or fiduciary relationship between the parties, or some conduct on the party which constitutes active concealment. So you don't have to tell them, but you don't have to tell the buyer about everything or anything, but you can't cover stuff up. There's a case where there are cracks in the foundation, and somebody put up at the last minute, put up some kind of fake, not wallpaper, but some kind of fake wall to cover up the cracks. You can't do that, but you don't have to tell them about the cracks. Normally, some affirmative misrepresentation, industrial waste on land allegedly used on his farm, land containing valuable minerals allegedly acquired for use as campsite, existence of, I don't know what that means, escrow, securing lien concealed, is required to impose upon the seller a duty to communicate undisclosed conditions affecting the premises. So, if I were to sell something to a client, because we have a fiduciary duty, I'd have to disclose everything. Caveat emptor is not so all-encompassing a doctrine of common law as to render every act of non-disclosure immune from redress, whether legal or equitable. So there are exceptions if it's particularly egregious. In regard to the necessity of giving information which has not been asked, the rule differs somewhat in law and in equity, and while the law courts would permit no recovery of damages against a vendor because of mere concealment of facts under certain circumstances, Yet if the buyer refused to complete the contract because of the concealment of a material fact on the part of the other, equity would refuse to compel him to do so, because equity only compels the specific forms of contract which is fair and open, and in regard to which all material matters known to each other had been communicated to the other. So basically, you'll only be forced to perform a contract if everything's known. Even as a principle of law, long before exceptions were embodied in statutory law, the doctrine was held inapplicable to contagion among animals, adulteration of food, and insolvency of a maker of a promissory note and of a tenant substituted for another under a lease. Common law is not moribund. Where fairness and common sense dictate that an exception should be created, the evolution of the law should not be stifled by rigid application of a legal maxim. The doctrine of caveat emptor requires that a buyer act prudently to assess the fitness and value of his purchase, and operates to bar the purchaser who fails to exercise due care from seeking the remedy of rescission. So you can't get out of a sale if you just don't know what you're doing and you're not paying attention, because that's not fair. You should have to at least do your due diligence. For the purpose of the instant motion to dismiss, plaintiff is entitled to every favorable inference which may reasonably be drawn from the pleadings, specifically in this instance that he met his obligation to conduct an inspection of the premises and a search of available public records with respect to title. It should be apparent, however, the most meticulous inspection and search would not reveal the presence of poltergeists at the premises or unearth the property's ghoulish reputation in the community. Therefore, there is no sound policy to deny the plaintiff relief for failing to discover a state of affairs which the most prudent purchaser would not be expected to even contemplate. I suppose that it's possible that, you're not going to call the Ghostbusters when you buy a house. The case law in this jurisdiction dealing with the duty of a vendor of real property to disclose information to the buyer is distinguishable from the matter under review. The most salient distinction is that existing cases deal with physical conditions of the premises and other factors affecting its operation. No case has been brought to this court's attention in which the property value was impaired as the result of the reputation created by information disseminated to the public by the seller, or for that matter, as a result of possession by poltergeists. So, yeah, that's an interesting distinction. The seller says a bunch of bad stuff about the property to the public, then they should have to disclose it to the buyer as well. Where a condition which has been created by the seller impairs the value of the contract and is peculiarly within the knowledge of the seller or unlikely to be covered by a prudent purchaser exercising due care, non-disclosure constitutes a basis for rescission as a matter of equity. So if the seller messes the thing up, then you get rescission. Any other outcome placed upon the buyer, not merely the obligation to exercise care in his purchase, but rather to be omniscient with respect to any fact which may affect the bargain. No practical purpose is served by imposing such a burden upon a purchaser. To the contrary, it encourages predatory business practice and offends the principle that equity will suffer no wrong to be without a remedy. So I'm trying to keep an eye on the Alicia case, the Andrews case. I'm assuming they're probably having dinner right now, but let me see. Defendant's contention that the contract, particularly the merger or as-is clause, bars recovery of the buyer's deposit is unavailing. Even an express disclaimer will not be given effect where the facts are particularly within the knowledge of the party invoking it. Moreover, a fair reading of the clause reveals that expressly disclaims only representations made with respect to the physical condition of the premises and merely makes general reference to representations concerning any other matter or things affecting or related to the premises. As broad as this may be, a reasonable interpretation is that its effect is limited to tangible or physical matters and does not extend to paranormal phenomena. Finally, if the language of the contract is to be construed as broadly as the defendant urges to encompass the presence of poltergeists in the house, it cannot be said that she has delivered the premises vacant in accordance with her obligation under the provisions of the contract writer. I love that argument. You're obligated to give exclusive possession of the house to the buyer. And, if there's a ghost, it doesn't seem like you've done that, have you? I love that argument. To the extent New York law may be said to require something more than mere concealment, to apply even the equitable remedy of rescission, the case of, I don't know what that says, not precisely on point, provides some guidance. In that case, the seller disclosed that an official map indicated 2 as yet unopened streets, which I'll call the ghost hunter, which were planned for construction at the edges of the parcel. What was not disclosed was that the same map indicated a 3rd street, which, if opened, would divide the plot in half. The court held that while the seller was under no duty to mention the planned streets at all, having undertaken to disclose 2 of them, he was obliged to reveal the 3rd. A few readings, yeah. In the case of Barr, defendant seller deliberately fostered the public belief that her home was possessed. That's really what this case comes down to. Having undertaken to inform the public at large, to whom she has no legal relationship, about these supernatural occurrences on her property, she may be said to owe no less a duty to her contract vendee, to the buyer. Exactly. It's been remarked that the occasional modern cases which permit a seller to take advantage of a buyer's ignorance so long as he is not actively misled are singularly unappetizing. Prosser. Whereas here, the seller not only takes unfair advantage of the buyer's ignorance that has created and, oh man, people are coming to see me talk. Is there an official registry yet? Oh, for the ghost? Oh man, I was watching Cat stream and now I'm watching myself. Hey everybody. Happy Friday to everybody. This is the, I'm reading a case about poltergeists. I'll give you guys some of the highlights after I finish this part up. Hey, Nesson, Lexi. Good to see everybody. What was the consensus on the Andrews case? It seemed like it was split, which is closer than I expected it to be. Okay, let me just finish this up. Application for remedy of rescission within the bounds of a narrow exception to the doctrine of caveat emptor set forth herein is entirely appropriate to relieve the unwitting purchaser from the consequences of a most unnatural bargain. Split? Yeah, that makes sense. Accordingly, the judgment of the Supreme Court, which dismissed the complaint, should be modified on the law and facts and in the exercise of discretion in the first cause of action seeking rescission should be reinstated without costs. Hey everybody, thank you for joining. Please hit like and subscribe. Good call. So this is a fun case. I should have waited until more people got here. I thought Kat was gonna come raid. But this is a fun case. If you want to look it up yourself, Stambovsky versus Ackley, in which if you go around telling everyone your house is haunted, you might have to live with that. Yeah, that's basically what it comes down to. But this is a fun case in which the seller of a house had been going around telling everybody, including newspapers, that his house was haunted for years. And went to sell the house, didn't tell the buyer that the house was haunted. The buyer got mad about it, sued to get out of the deal. And the court realized that because the seller had repeatedly said that the house was haunted, they had to treat the house as if it was haunted. So legally, the house was haunted by poltergeists. And then there were just a series of Ghostbuster puns, or ghost puns, throughout the entire opinion This is my personal favorite. I'm not going to reread the whole thing. From the perspective of a person in the position of plaintiff herein, a very practical problem arises with respect to the discovery of a paranormal phenomenon. Who are you going to call? As the title to the movie Ghostbusters asks. Thank you, Kat. In Nyack, New York. I actually dated somebody from Nyack, and I would always call it Nyack, just to annoy her, because I thought it was funny, because, I was young and terrible. Nyack. It's funny to say. Feels like an old-timey New Jersey accent or something. Oh, man. I went through my two favorite cases today, my two most relevant cases. Oh, wait, before anyone goes, I need to show everybody my Nancy Grace outfit. Here we go. This is the mascot of the stream right here. I'm a shark. This is a vampire. Cat out here fiddling other chest. I just asked my kid, she knows where the house is. She said it's right by where she hangs out. Yeah, it's actually, I looked up the address the other day. It's 1 something street. I'll show it to you. I believe it is this one. Here we go. There you go, that's better. It's from 2016. I believe Sotheby's was selling the house. I haven't seen you guys in about 10 minutes. Every Halloween, you can be sure to see costumed children collecting candy and carved pumpkins adorning windows, but if you live in Nyack, you are guaranteed to also hear about the legend of one Levita Place, which was deemed a legally haunted house in 1991 by the New York Supreme Court. I don't think it was the Supreme Court, was it? No, it's appellate. Here we go. So this is the house. We can look it up on Google Maps later. Over more than 2 decades, I've had the opportunity to represent it for sale twice and have an insider's view of what has affectionately become known as the Ghostbusters house. Yeah, I think it's like 1.5 or something. Take a step back in time to the late 1980s, and I was at the start of my career as a real estate broker. I was asked to represent One Levita Place, a late 1800s house that had been on the market for a couple of years with another brokerage. I can make this bigger. The owner, Mrs. Ackley, was very proud of her house, but insisted she wasn't the only inhabitant. She described 2 women in hoop dresses and a little man in a Revolutionary War era red coat that also would visit. The only catch is they were not living. This fact didn't seem to disturb Mrs. Ackley, but I remember I would often get nervous going down to the very large dark basement to put on whatever few lights there were. After about a year, a buyer was interested and put a deposit down. Right before it closed, the seller asked us to advise the buyers of the ghost visitors, which we did. They still want to proceed and jokingly said they would call the Ghostbusters in, referring to the popular movie. 2 weeks after... Oh, man. This seems like a rewriting of the facts. 2 weeks after contracts were signed, however, the buyers had a change of heart, and the rest, as they say, is history. The case went to court, and while my firm and I were released from the case, the owner-seller was held liable. Ultimately, the case settled out of court, but along the way, the New York Supreme Court ruled the home legally haunted. I should be clear, the court didn't actually believe in ghosts. That's not quite how that worked. Oh, thanks for the raid, by the way, Kat. I should have said that. I don't know if I did. As a result, New York State real estate license law changed for a brief time, requiring the broker to have to automatically disclose if a homeowner said they had a ghost. Again, not really true. Since then, the home has gone down in pop culture history, with media from all over covering the story. When the home went back on the market, I showed it to several clients, and one would tell stories of feeling something brush against him in the hallway. Eventually, the home sold for about the same price as it would have sold the first time. Fast forward to about 2012, the third owner after Mrs. Ackley called us to list the home for sale. While the owner didn't mention the ghosts, the first day I had a showing there, I had my own supernatural experience. As I went around the house putting the lights on, the doorbell rang. As I made way to the tower room on the top floor. The clients had just arrived to view the home. As I put the last light on, a light bulb burst and a small fire started. That seems like a problem. The flame grew larger and a nearby shade caught fire before I could put it out. You're just going to end the story there? What happened? Did you put the fire... Okay. Was it a ghost I encountered that day? Did they object to the house changing hands again? Many in the psychic world say there is no such thing as coincidence. Perhaps the activity at one limited place was simply an old soul wanting me to know they were still there. We will never know for sure. One thing is certain, however, the next time you hear a creak in the floor or a voice in the night, just keep moving forward and don't look back. I'm concerned with the wiring in this house, to be honest with you. This feels like a practical problem. Less so, yeah, exactly, Lee. That's more my concern at this point. Like, stuff just spontaneously catching on fire due to a short or some kind of exposed wiring. That seems like a problem. And I'm not like a real estate guy, but I don't know, man. Goodness. Man, that was the stuff that I planned on covering today, but you guys just got here. Guess I can do one more thing. Want to read an AI case? Oh, thank you. Please tell me the judge's name is Ray Parker. I don't know the state court's judge's name. You mean the Stambovsky case? Spontaneous. Yeah, that's a good thing to be scared of. Not in the appellate court. Let me see. No, it was Judge Lehner. It doesn't look like it was Ray Parker. Thank you for the donation. I really appreciate that. Very appreciated. There is an AI case, an AI sanctions case that I've been meaning to read. The haunted house case, yeah. Yeah, I don't think it was Parker. Do you know a Judge Parker? Not this one? What case is it? This is one of the ones I want to take a look at. 1991? Yeah, that's right. I think the trial court was 90, and then the appeal was 91. Ray Parker. Oh. Oh, that one went over my head. So this is an interesting AI case because it's a criminal case. Usually they're in civil. Oftentimes they are like pro se civil cases. Not uncommon at all. Well, let's see. For ease of the reader, the court first provides the short summary of the sanctions ruling, followed by the detailed opinion. Determined that attorney... This is just from 3 weeks ago. Determined that James Johnson utilized an AI program in the drafting of a motion, which as a result contained fabricated citations that he failed to check prior to submitting the motion to the court. The issue was discovered by opposing counsel, confirmed by the court, and acknowledged by Mr. Johnson. After a careful review, the court determines that Mr. Johnson's conduct was tantamount to bad faith. Therefore, the court sanctions him under its inherent authority and orders as follows. Attorney Johnson is reprimanded, and this reprimand shall be published. Let me see. In any case, in any court wherein he has appeared as counsel, and final judgment has not been entered. So he has to file it with every case that he's working on. He shall file, not under seal, a copy of this memorandum in any case in any court wherein he appears as counsel for the next year, shall provide a copy to any jurisdiction under which he is licensed to practice law within 2 business days. File the notice of compliance with the court. Clerk of court shall send a copy of this memo to the Alabama. I just see Atlanta everywhere now. Everything's Atlanta. Alabama State Bar for review. They're referred to the State Bar for any disposition deemed appropriate. The undersigned recommends that the public reprimand and sanctions contained in this order be the final action with regard to these particular allegations. So they're not asking for any punishment, just notice. Sending a copy to the other Alabama districts, and imposing a $5,000 fine. Listen to Maya's testimony. What case is that from? Okay. James Johnson, counsel for Glennie McGee, good name, filed a motion to continue the trial in both cases. The drug conspiracy case and the financial fraud case. This sounds like a fun case. Oh, save Maya. In its response in opposition, the United States indicated that counsel for McGee appears to have fabricated citations in that he cites several non-existent cases, attributing false quotations to others and directing this court to precedent that the Supreme Court reversed more than 40 years ago. Say Meyer, got it. McGee's incorrect and outright fake citations, many of which the United States has been unable to locate despite diligent searches, bear the hallmarks of legal authorities hallucinated by AI. In its opposition, the United States describes at length the basis for his belief that counsel for McGee fabricated citations. In the light of the seriousness of the accusation, the court conducted independent searches related to the citations at issue. Regarding the cases that allegedly do not exist, the court search revealed the same problems, and the allegations made by the United States were correct. The cases do not exist, citations did not go to the reference names, and/or the cases did not relate to the issues at hand. For the cases that relate to misrepresentations or false quotations, the search did not fare any better for defending the use of those citations in the manner and context given. So AI hallucinates, yeah. Finally, the court also agrees that certain case law cited was long ago overruled by the Supreme Court. I will say that I feel like people will get away more easily if it's an AI thing rather than like doing the exact same thing without AI. Like if you just make up a case and just intentionally, commit a fraud upon the court, I feel like you'd get punished more harshly than if you just say, oh, it was AI, which doesn't really make sense to me. Like, I feel like the fact that it's AI is just a red herring. It should be treated as just fabricating cases rather than, hallucinating cases. Therefore, the court issued a show cause order making these points and instructing Mr. Johnson to show cause why he should not be sanctioned for making false statements of fact to law to the court. Part of the response, Johnson was ordered to append to his filing copies of each allegedly fabricated legal authority, or if he cannot provide such copies, to submit a sworn declaration that provides a thorough explanation for how the motion and allegedly fabricated cases were generated. This is where federal judges will get you. Anytime you have a show cause hearing, not that I've ever had to do one. On that side of the show cause hearing anyway, they will make you put everything into writing beforehand so that you can't change your story at the hearing, among other reasons. But you'll get locked into one explanation prior to the hearing being held. Pretty much every time. That's kind of the go-to move. On July 14th, 2025, counsel appeared on behalf of Mr. Johnson. That's smart. Don't do it yourself. Counsel for Mr. Johnson filed a response along with an affidavit for Mr. Johnson. The response asserts the use of fictitious authorities was an embarrassing mistake, but that Mr. Johnson did not knowingly or intentionally use a resource that he thought would or could make up the citations. That's ridiculous. The response further argues that Mr. Johnson's conduct, while negligent and or ignorant, did not rise to the level of reckless or bad faith. I can't believe that might have been viable like 3 years ago, but come on. Exhibit 1, there's a declaration from Mr. Johnson. In the declaration, Johnson apologized to the court, opposing counsel, and his client for the inadvertent mistake which he made under time pressure and difficult personal circumstances. He indicates that on July 3rd of this year, while at an out-of-state hospital attending to the care of a family member, he received a notice that the pretrial conference in the financial fraud case had been moved up on the court schedule. Therefore, he needed to file his motion to continue before the holiday weekend. Mr. Johnson indicated he typically used Fastcase, a research tool provided by the Alabama State Bar. In this instant, he used a Microsoft Word plugin called Ghostwriter. We have another ghost. Ghostwriter Legal to find additional cases to support the motion. Though Mr. Johnson could not remember the exact search terms used, he indicates a returned a list of cases which seemed relevant and legitimate, which he inserted into the motion to continue. He further indicated that he used Ghostwriter because it appeared automatically in the sidebar of Word, while Fastcase required opening a separate browser to access through the Alabama State Bar website. Is using AI that much worse than just asking Google? It's probably more, I don't know. I mean, I think if you're not reading the cases, can't you just pay for a subscription to one of those case law? Yeah, you can. 4 ratings and a 3. Yeah. It's not that hard to get the case law for this. Since he was only on his laptop, he found it tedious to toggle back and forth between programs on his laptop with a touchpad. That's true. That is annoying. I agree with him on that. Unfortunately, he fell victim to the lure of a new program that was open and available. Mr. Johnson indicated that he was aware of news accounts about ChatGPT and fake citations, but he thought that Ghostwriter Legal was a reliable research program. He further includes excerpts from promotional materials and reviews as it relates to Ghostwriter Legal. He further asserts that after additional research, he now understands that many paid and free AI programs can create citations that do not exist and are unreliable. So this is a complete, red herring. It doesn't matter. None of this matters because you didn't read the case. It's that's the problem. Whether it was AI or not AI, it doesn't matter. Even if Ghostwriter was a completely legitimate thing, and every other time anyone has ever used it, it hasn't hallucinated cases, you still didn't read the case and do your job. That's what you're paid to do. I'm sure he billed his client for that time. He states, when I used Ghostwriter, the idea that the search results, which looked authentic, could be completely made up, never even entered my mind. Whether that, apparently it didn't enter your mind to read the case either. Whether that was due to my naivete related to AI or overblown puffery by the company, I will never make that mistake again. Johnson says it was an honest mistake and that he never intended to mislead the court or opposing counsel or to cast an unfavorable light on his client. The court held the show cause hearing on July 16th. Now, usually I read these in advance, so I know I'm not going to read something that's terrible, but I've never read this before. I'm oddly excited about getting the answer on stream. At the hearing, let me see. His counsel acknowledged the error. He accepted responsibility for using a program without checking the citations. The United States also asked to be heard and provided its own exhibits about Ghostwriter Legal. counsel for the U.S. noted that it seemed confusing that Mr. Johnson disclaimed use of ChatGPT when the very information from Ghostwriter Legal made it clear that it used ChatGPT as its default AI program. At the conclusion of the sanctions hearing, the court inquired of defendant McGee whether he was comfortable proceeding with Mr. Johnson as counsel, and he responded, "No, sir, I'm not." That's an excellent answer. After a short recess, my God, I can't read today. After a short recess, during which Johnson and McGee conferred with each other, the court held an ex parte hearing to address the release of Mr. Johnson and appointment of new counsel. Ultimately, McGee stated he wanted a new counsel and understood that it would result in a significant delay of trial to give new counsel time to prepare. Let me see. Court appointed Darley from the panel to represent defendant McGee. Subsequently, McGee requested to proceed pro se. The court conducted a Feretta hearing on August 4th, determined that he made a knowing and voluntary decision to proceed with self-representation, and appointed Darley as standby counsel to assist. Court further held a scheduling conference for the drug conspiracy and fraud cases, set for January and February of this coming year. A delay of roughly 5 and 6 months. That's not nothing. YP. During YSL trial, I saw several times on the prosecutor's computer it said AI legal. Yeah, I think it would be allowed. It's just you have to. Camera was moving in the Fulio case. You have to. You still need to do everything correctly. You still have to do all the work. Any chance you could explain the Second Court of Appeals? I haven't looked at it yet. I know it happened. I haven't looked at it yet though, but I can do that for sure. From what I saw, I think I saw that they vacated everything and allowed the plaintiff to go forward on basically redo one of the claims. I don't know if that's true, but that is what I remember. It has to go retrial. Yeah, that's what I thought. And I don't think they can make all the arguments that they did in the first one either. They can only make the, I think, intentional infliction of emotional distress claim. Okay, I opened up the Andrews case. It looks like it's still deliberating. Somebody in the Law and Crime chat just said they can't go home without a verdict. You hear that? They are stuck. They're going to be locked up until there's a verdict. Are they like sequestered in a... They sequestered or something? I don't know. People are making sentencing guesses. I don't even know that yet. They're not even at that phase yet. Okay. All right. I love Law and Crime chat. Looked like an earthquake in the courtroom. Yeah. All right. Where were we? Many harms flow from the submission of fake opinions. Mata. I actually have that case too. Where are you? That is like the first major AI case. It gets cited all the time. Concept is well known, a long-standing principle in the practice of law, yet the improper use of generative AI is a problem that sadly is not going away despite the general knowledge in the legal community that AI can hallucinate and make up cases. Look, so I need to completely cover up the Law and Crime chat or I'm just going to be distracted by all this. Oh, it's just moved again. The camera moved again. Thank you. Hospital and social workers really don't appreciate the trauma they can cause. Yeah. Okay. Hallucinations have been reported on extensively in media, not just in legal context, and the subject of many seminars and CLE trainings offered by bar associations, articles written in journals, and numerous well-reported instances of courts sanctioning attorneys. Somehow the message still has not been hammered home as the epidemic of citing fake cases continues unabated. Actually, there is a website that I found last night, I think. Well, I know it was last night. It has like a running total Here it is. Of hallucinated cases. And it updates quite frequently. This website. Oh, where are you? There you are. So they have 494 cases so far. I saw a judge get caught on... Yeah, there have been a few judges. There was a couple of federal judges that got caught quite recently. A few judges. But yeah, this has pretty much all the cases here. Monetary penalty, $1? Is that right? But you can go straight to the order here. How does AI hallucinate? Yeah. I mean, I think it just like mimics language from citations. So it just writes language that looks like a citation. That's not really a citation. Is there actually a $1 cost? That would be hilarious. But yeah, it has links to all the orders and all the opinions. And it actually has several cases from other countries. British Columbia here. Yeah, I agree, Lee. I think it needs to be significantly more. You see a lot of cases it's pro se people who just, they're doing their best. I don't really mind it as much from Argentina. I don't mind it as much when it comes from pro se people. Like, you still shouldn't do it, but, I at least get it. But with lawyers, it's just unacceptable. So, Italy, Israel, Czech Republic. It's like a plague. Find use AI. Yeah, I think AI, it doesn't even save time for me. I've tried to use it a few times, but I end up spending more time, trying to make it viable than I do actually, just doing it myself. Because you have to, check so much stuff so carefully, and it's just more time. Because you have to check, make sure the case exists. You still have to read the case, and then make sure, the quotes are accurate. And you have to go through everything carefully because I'm terrified of this happening to me. But it does have uses. I like to use it for spell check, not spell check, proofreading. It's pretty good at that. It's actually not. About half the time it's wrong. But I do use it for proofreading. Sometimes it'll give corrections. Sometimes it'll also just say that I did things wrong, and then I'll check. It'll invent typos because it doesn't want to say there aren't any. So I'll go and check, and it'll be right. It's like making up lies about me. Like my computer's lying to me, telling me that I'm bad. I'm getting negged by my AI. I've used it to help write descriptions for listing. Yeah, that can be helpful. Sometimes if I can't think of how I want to say something, I'll say the general thing, but in a bad way, and I'll be say this better. And then I usually won't keep it, but it'll give me an idea on how to say something. Okay. So eBay, yeah. There are different ways to use it. I think useful. But this idea that AI is going to replace lawyers in 6 months or a year is kind of crazy. Maybe someday, but it's a ways away. All right. Where was I? Has not been hammered home. So many cases. No one reads. There's a new case here. This is so many. Look at all these. This is crazy. Good Lord. The court notes this enormous string citation is only a small segment of what the undersigned found. Simply put, the legal community is well aware of the dangers and pitfalls of using AI shortcuts without further review or supervision. Clear, the court's not saying AI has no practice, no place in the practice of law. AI can absolutely be a useful tool, but in the same realm as supervising subordinates' work or checking citations found indirectly, a lawyer is absolutely responsible for the citations and submissions to courts. Maybe they thought no one yeah. Yeah, there were a couple of judges that got I think there were 2 federal judges. Let me see. Let's see. This is paywall. I'm not going to use that one. Yeah, I'll just pull this up real quick. This was the fastest one I could find. This was 4 days ago. Ackley spoke on the Senate floor, discusses oversight of federal judges' AI use. He exposed 2 federal judges whose court staff used AI to draft inaccurate court orders that the judges approved. Judges Wingate and Niels, District of New Jersey, and what was the other one? Wingate, Niels. Oh, Southern District of Mississippi. So yeah, not just well, I guess judges are lawyers, but there we go. While not applicable in this case because it is a criminal case as opposed to a civil case, which is, I'd say, worse. He could be. Oh, the senators are. I feel like once you're in Congress, you lose your knowledge of how Twitter works. While not applicable in this case because it's a criminal case opposed to a civil case, the court notes that Mr. Johnson noted on several occasions that his background consisted primarily of civil litigation, so he should be well familiar with Rule 11. States that by presenting, basically it says that everything that you file has to be signed and you are responsible for it. Yeah. Rule 3.3, a lawyer shall not knowingly make a false statement. Responsible for pleadings and other documents prepared. A lawyer is not required to make a disinterested exposition of the law, but must recognize the existence of pertinent legal authorities. Just stating the rules here. Just explaining the court's right to sanction. Courts basically have broad discretion in sanctioning people as long as it's, in connection with administering the court and making sure that things run smoothly. So, turning now to this particular case, the harms that flow from the submission of hallucinated or false cases are not minimal. Recently, a sister court articulated them at length. The opposing party wastes time and money in exposing the deception, and the client may be deprived of arguments based on authentic judicial precedents. While the court takes time to investigate, other cases may be disrupted or deprived of judicial attention. It promotes cynicism about the legal profession and the American judicial system, and a future litigant may be tempted to defy a judicial ruling by disingenuously claiming doubt about its authenticity. And the public, who taxpayer dollars pay the lawyers at issue here, is justifiably horrified and outraged when filings in acquittal law substitute lazy, convenient fictions for the truth. Even in cases like this one, where lawyers who cite AI hallucinations accept responsibility and apologize profusely, much damage is done. The opposing party expends resources identifying and exposing the fabrication. That's basically the same as the first paragraph. Let me see. Again, establishing its authority. Despite the gaps in the rules above, the court is left with its inherent authority, which is designed precisely for this type of misconduct, something that does not expressly fit into a specific rule, but is clearly misconduct. Uh-oh. We got a typo. But it clearly is misconduct, because what is clear to every lawyer and judge is that providing false statements and citations generated by AI and provided without any independent verification violates the spirit and intention of candor and causes great harm to the court. Turning now to the analysis of the case at hand involving Mr. Johnson, the court notes that the written response and the oral arguments presented at the show cause hearing took slightly different approaches. Interesting. This is kind of what I was saying earlier. Don't commit no crimes, exactly. How the court will make you put everything in writing so that you can't change your story once the court starts questioning you at the show cause hearing. The written response seems to indicate that the applicable standards do not allow or require sanctions, though it does acknowledge that it does not mean the underlying mistake is excusable. The court can appreciate the technical arguments that counsel for Mr. Johnson attempts to make, even as he softens it with in candor that may sound like an effort to hide behind technicalities, which is not Mr. Johnson's intent. This is why you have a lawyer, even if you are a lawyer. Because if somebody's making a technical argument on your behalf, it's a lot more forgivable than if you're doing it for yourself. Because that's what lawyers do. But if you do it yourself, it's like you're just trying to be shifty and avoid responsibility. Even though functionally it's the same thing. During the hearing, Mr. Johnson essentially acknowledges his error and throws himself upon the mercy of the court, though as discussed later, it was clear he did not fully appreciate the gravity of the consequences, as they may relate to his client. Mr. Johnson admits he used Ghostwriter Legal to aid in the drafting of his motion to continue, without verifying the citations and statements it provided. He does not contest that it was his responsibility to review the authorities. The court notes from the outset that it does not matter that there may be actual authorities that stand for the proposition that the bogus authorities were offered to support. Ultimately, the court finds that to be irrelevant and does not remediate the wasted time, additional work, and harm caused. Any sanctions discount on this basis would amplify the siren call of an unverified AI for lawyers who are already confident in their legal conclusion. The court agrees and rejects any such notion. Because some authority exists to support a legal proposition, it should negate the harm caused by false cases. Put bluntly, absolutely not, period. End of story, I'll stop. Dramatic. But I agree completely. Hold on, let me check the Alicia Andrews thing real quick. Although I assume one of you would tell me if it is actually, yeah, it looks like nothing. There are 6,600 people watching the Florida Judicial Seal. That's impressive. Let's see. The court notes the majority of cases found involving AI cases relate to civil litigation, and the harm there is certainly great. You know me too well. That's exactly what I was thinking. This is the part I was interested in, that it's a criminal case rather than a civil case. So instead of money, it could be losing, your life, your liberty. But this is a criminal case in which the defendant had an appointed counsel which is paid for pursuant to the CJA, I don't even know what that is, which are public funds. It is clear from the show cause hearing, that one particular point Mr. Johnson did not anticipate is that his client would lose confidence in him and request a new lawyer. This was evidenced by his look of shock, dismay, and display of emotion when Defendant McGee indicated he no longer had confidence in his counsel and wanted a new counsel, even though it would result in a significant delay in the trials for these two complex criminal cases. This is understandable given the seriousness of the offenses alleged against the defendant. The delay caused by Johnson's actions harmed the defendant, the public, the United States, and indeed the court, as a result in a further delay in resolving these cases. Additionally, in the case at hand, it results in the significant increase in cost because a new attorney essentially must start from scratch in reviewing the extensive discovery and the scheduling of 3 to 4 weeks for trial in each of these cases. The harm is not inconsequential, as public funds for appointed counsel are not a bottomless well and are a limited resource. Yeah, I mean, also he's not going to have a lawyer. It's not just the expense, it's the fact that he's going to be self-representing in a complex case. And he would have had a lawyer if his first lawyer had done his job correctly. And even though it's his right to self-represent, it's never a good idea. It's certainly not a case this complex. The court further has no difficulty finding that Mr. Johnson's misconduct was more than mere recklessness. The court knows that errors can happen in filings despite attorneys and even judges' best efforts, yet the insertion of bogus citations is not a mere typographical error, nor the subject of reasonable debate. It is just wrong. Exactly, Carmi. Carmi knows. Carmi knows not to use AI. He just tried to run out the door. He was so disgusted by the AI. That's a smart dog. Oh, man. Where was I? A plethora of general awareness from courts, bar associations, and the legal community at large about the risk of bogus... Scared you? Sorry about that. He'll go find another prison to hang out in. He better not. I already bailed him out once this week. He's going to have to spend the weekend in jail to learn his lesson if he runs away again. Let me see. I can't lose my spot. Let me see. Johnson acknowledged he was aware of such issues. In fact, he states he was unaware that a program such as Ghostwriter Legal could make such errors does not negate... Like, what do you... It's called Ghostwriter Legal. Like, what do you think it's doing? Like, it's writing for you, apparently. So I don't know, like, what you think it is. Okay. Having been aware of the pitfalls of a failure to check citations supplied by another source, he still parroted citations generated by Ghostwriter Legal without verifying them. Such conduct reflects the complete and utter disregard for his professional duty of candor and is tantamount to bad faith. Make him deliberate with the Andrews jury. Yes. Because of their potency, inherent powers must be exercised with restraint and discretion. It'd be really funny if one of these cases were fabricated. Okay. The court already made its initial finding above, but notes specifically here that the conduct was intentional. Johnson intentionally utilized a program that supplied him legal argument, authorities, and citations without making any effort to confirm that the information provided was accurate or indeed even existed. Johnson indicated he was aware that AI programs, such as ChatGPT, could make sure errors. Where that should make such errors? That's supposed to be such errors, maybe? Yeah, it's probably supposed to be he was aware that AI programs could make such errors. Further, despite Mr. Johnson's protestations that he was not aware that Ghostwriter Legal could make such mistakes, the court The court finds it is a distinction without a difference. Counsel was aware that he had an obligation to check his authorities and citations, and instead merely parroted what the program spit out. Even if he was not aware that this particular program could make such errors, Johnson had an obligation to check the citations before signing and filing with the court. Exactly. Any reasonable investigation would have quickly shown the problem. Johnson failed to discharge the most basic of responsibilities of a lawyer to verify the statements in his motion were true. This is more than mere negligence or recklessness. It is unacceptable and caused significant real-world implications. In the delay of 2 cases, the further use of limited CJA funds for a newly appointed counsel begin anew, a significant waste of time for the court, and a delay in the public and defendant's right to prompt adjudication. Definitely not. ChatGPT never hallucinates. Given the broad attention given to the problem with AI-generated cases and authorities, no attorney can claim ignorance or simply bury their head in the sand when it comes to their own use of AI. Accordingly, this conduct is tantamount to bad faith and sanctionable. To rectify the bad faith misconduct in this case and vindicate the lawful authority of the federal courts, lost my spot. To keep proceedings free from falsehoods, such as the one at issue here, the court will impose the least severe sanctions that it finds likely to deter future similar misconduct. In exercising its inherent authority, why do they call it hallucinating, though? I don't know. They're seeing something that's not there. It should just be making it up. In exercising its inherent authority, the court assigns a significant value to the deterrent functions of a sanction. has become clear that basic reprimands and small fines are not sufficient to deter this type of misconduct, because if it were, we would not be here. In any event, a fine would not rectify the egregious misconduct in this case. Rather, the court finds that a public reprimand with a limited publication requirement, referral to the Southern District of Alabama's advisory panel for review on removal from CJA panel, and a fine in the amount of $5,000 payable to the CJA fund from which counsel was originally paid. I hope it's at least the full amount they were paid. Oh, I think I saw the camera move again. Maybe not. The court would have also considered potential disqualification, but that was rendered moot by the fact that the defendant requested new counsel. Johnson has... Oh, the camera moved. Never mind. As Mr. Johnson already submitted and been paid for his work, in this case out of CJA funds, the court cannot merely reduce his fee petition. Instead, the court must assess a fine which will replenish and offset some but not all of the funds that will be expended by the new counsel. Just make them repay the money. You can do that. Anyway, $5,000. Publishing the case, or giving the case in all cases he's appeared. And that's it. $5,000 is certainly better than the amounts I've seen in the other cases. Like $1,000. The one that I'm gonna get to eventually, unless Kat did this one. Did you do this one? Billy Stickman, the GOAT of AI, Tyrone Blackburn. I can't remember if I did this one. I read this again. Oh, man. I think I read this too. I'm pretty sure I remember reading this phrase into a camera at some point. The judge shouldn't sentence the lawyers who use AI. Yeah. Okay, that makes more sense. Yeah, I think that last case we looked at was particularly bad because now the guy's he doesn't trust lawyers, and now he's not going to have a lawyer when he definitely needs one. You know what I should do? I should just read the Law and Crime Chat sometime and just react to the Law and Crime Chat because it's like in the corner of my eye and it's just a cesspool. My goodness. Somebody's just talking about Diddy in here for no particular reason. Diddy ain't done shit. It's a money grab. What does that have to do with anything? Somebody says, free everybody that is innocent. Keep all the guilty people locked up. I mean... That makes sense. We could start with trolling it to distract you further. Or we could start trolling. Sometimes I try to troll in the Law and Crime Chat, but like... I think people, it's like, I can't think of anything like dumb enough. Now they're talking about Charlie Kirk. I'm pretty sure Charlie Kirk got his wings, big dog. What? Skinny girls hurt my baby leg. That chat makes me want to lose my... Diddy was sent to his final home. This is so confusing. Charlie Kirk killed Little Taz? Oh, now there's just somebody spamming the N-word. This is just... Who is I don't know. Taz, like... Oh, man. He's probably hanging out with, what's his name? Was it Lil Mike and Rel? Not Rel. Lil Mike and, who's the other one? Petition to lock Cyborg Static up with Alicia Andrews. Right, Quez. I want to say Quay, but I'm like, nah, it's not. That's not this one. Taz was the dog. I didn't know that one. This is incredible. Elise says, innocent. If you think her attorney and sister would lose this case, her sister is why she kept smiling. Makes sense why she didn't have tears. If she would have got Pizza Hut, she might have got a better lawyer, this McDonald's food. These people, somebody just called her sugar britches? I'm sorry, I'm just, I can't do this. I mean, I can do this, and I'm having a great time doing this. I'm sorry. This is like looking at a car wreck. Hopefully they're not coming back tomorrow. Yeah, no, that's... Man, this camera... The totality of the evidence proves guilty beyond a reasonable doubt. In all caps. Like, what? Like, are they trying to convince me? Like, look at this. In their chat is subscribers only. Oh, really? Am I a subscriber? Unfortunately. Beer is disgusting. Upgrade your life. Disagree. You know what time they started deliberating? Like 4 o'clock-ish? These people are like... Like, there's not even anything going on right now. They're, like, arguing in the chat. Six... Okay. Okay. Oh, I see. So that was, what, like, an hour and a half? And what time is it there now? 8:30? Damn, that sucks. Free DJ Academics. I disagree. If Academics goes to like, I'll defend anybody, but I'm not defending that guy. He can go to prison. 8:22 and they're getting dinner. Just let them go home. I feel like this is like having the jury deliberate this late. It feels like they would just reach a verdict because they don't want to be there anymore. Like, do you want a hangry jury? I mean, I guess to get food, but like... Free Quando Rondo? Is he in prison? There's like a lot of Diddy talk in here. Free Oprah. What's on the menu Monday we come back? Probably send kids out. Yeah. Man, these people are terrible. I was really afraid that Quando Rondo's nickname was going to be Quay. I would have had to stop doing YouTube if that was the case. There's so many quays. There's a quay in every case now. Oh, man. Oh, man. I'm sorry. I've just been staring at this. This is probably not good stream content, me just staring at the law and crime chat, but I can't look away. Hung or not guilty. We're past the window of guilty. Okay, people, it's official. Alicia Andrews has not been convicted. You don't have to worry. We're past the window of guilty. I got the outfit. Maybe they'll go to teasers after deliberation. Get a Blue Flame or Club Crucial. Club Compound. Press the X on the law and crime chat. That's even worse, though, because it's worse like just knowing these people are talking without me seeing it. They go until midnight. Ooh, here's a case. Kat and I were supposed to do something about this case. Because I think it's still going. But then, like, we agreed, and then I never did anything about it. This is a habeas case in Georgia. I think it's still pending. It's in Butts County, which, because I'm 12, I find funny. You're tired for 2 weeks. Ooh, wait, I think I have the bookmark on this. There we go. No! See, some of these counties in Georgia, their websites are from like just 800 years ago. But they actually have a decent I can never remember if you do last name first on this one. Yes. This one here. I think it's still pending. Yeah, it's still proceeding. But this is a habeas that's been going for like decades now, I believe. Jury question. Am I live? I hope the jury question's like, why were you so mean to that defense lawyer? Fred Head? Oh, let me see. It did. It did say that. Warren King versus Fred Head. Oop. That was an excellent spot. It's probably the warden, I would guess. It's just the underlying... Keep an eye on the Andrew's thing, but not seeing it. But okay, this is the PDF here. I'm just gonna read like the intro, I guess, unless it's 50 pages long. I can read through that. I'm kind of waiting to see the jury question. I'll probably head out after that. But it's hoping we see it. Warren King was 18 years old with no history of violent crime when he and his older cousin Walter Smith were arrested for the murder of Karen Crosby, who was killed by a single gunshot wound during an attempted convenience store robbery in the small town of Surrency. Though both claimed the other was responsible for Ms. Crosby's death, it was undisputed that Walter Smith had bought his uncle's gun and a mask with him while he drove around town looking for Mr. King to join him. When Mr. Smith found Mr. King, he was biking to a friend's house with the snacks he had just purchased. Mr. King's case proceeded to trial first in September of '98. Mr. Smith testified for the state against Mr. King under a grant of use immunity. That's concerning. His testimony was the state's most damning, as he was their only eyewitness and claimed that Mr. King had initiated the crime, had shot and killed Ms. Crosby, and immediately after had made callous remarks about Ms. Crosby's death. I had a professor, retired cop, never get a job overnight at a convenience store or gas station. Yeah, that's a dangerous job. That and like cab driver. Yes. Mr. Smith's testimony was the state's only evidence indicating that Mr. King was the more culpable defendant. On cross-examination, Mr. Smith denied receiving any deal or anything. Okay, here we go.
All right. Does criteria number 1 in the definition of a principle apply in the case of second-degree murder, signed by the foreperson? Right? The legal answer is yes, correct?
Yes.
Right?
Criterion, you're talking about the element?
Yes.
That's the exact. Does criteria number 1 in the definition of a principle apply in the case of second-degree murder?
That's interesting.
I don't know what criteria. If they're talking about the element, I guess I want to clarify that before I just send back an answer. I don't know what they're referring to when they say criteria.
All right. Let me take a look. I'm assuming that's what they mean.
It seems like a clear yes.
So you want me to send a question back, or just bring them back and ask them? Or bring them out and ask them?
I guess they can come out.
Let's take a look.
So they're asking about
Not in this case.
whether principal liability applies to second.
Correct.
Okay.
Yeah.
Jail's just confirming.
Seems like they're probably not finding on first degree then? I don't know.
Okay.
I'm confused.
Very good.
Like, why are they asking specifically about second degree? That's not loud enough? Or my volume? Yeah, it means like, I assume that means they say yes. Oh, mine. Sorry, I was leaning back. Seems like not guilty on first degree, probably. Because they're asking specifically about second, maybe? Or they might just have a general question and haven't even gotten that far yet.
All right.
First degree plant?
Okay, very good. Welcome back, and I received the following communication from the jury. This criteria, number 1, is the definition of a principle applied in the case of second-degree murder, signed by the foreperson of the jury. And by criteria, do you mean element 1, the defendant intended the crime to occur? Okay, so any objection to me answering the question? Okay, someone nodded their head yes. Is that correct? Yes? Okay.
No objection.
Okay, the answer is yes. Okay? All right. It does. Okay,
Yeah, maybe
very
we should
good.
not-
Sorry about staying so long for the pizza again here, okay? It's coming, they promised us, okay? All right. Okay, very good. Thank you all. You can,
All right.
resume your deliberations.
That kind of seems to suggest not guilty. But I mean, it's like, don't rely on it. Second is accidental. Oh. Let me check.
Okay, very good. Thank you.
No. Why is this so difficult? Oh, I didn't type murder. That's important. That probably makes a big difference. It's first degree. Second degree. Ba-ba-ba. Okay, perpetrated by any act. It seems like it's kind of like felony murder. Unlawful killing of a human being when perpetrated by any act imminently dangerous to another and evincing a depraved mind regardless of life, although without any premeditated design. Okay, so second's just not premeditated. Yeah, like you were right. That's right. You are getting your law tips from a shark. Why did the chat stop? Come on, Law and Crime chat. Yes, Alicia won. She can still get life for the conspiracy. It seems like it means they're like, they didn't think that they knew that it applied to first degree. And they didn't find that. And so they wanted to see if it also applied to second degree. And you were right, YP. You knew more than I did. Maybe. That seems kind of like not guilty to me. But it can be a fool's errand trying to guess from questions what they're thinking. I couldn't really hear. They're still waiting for food. Yeah, they're asking about whether one of the elements applied. Whether they're asking whether she needed to mean, whether she intended for them to carry out the murder, I believe. I don't know the exact wording. This chat, man. I really can't. Oh, I didn't hear that part, Matthew. The food's still, that's insane. If the food's not there, like, it's 9 o'clock. I wonder if the judge's calendar Yeah, I wonder if the judge has like a trial next week or something and wants it done this week or as soon as possible. Ooh, now somebody's referencing YSL. Alicia is innocent. If you think her attorney and sister... I read this part. They're just spamming this. Just like YSL, she had no gang relation peeps. Much I love YSL. I wouldn't say that's accurate. Okay. On a cross-exam, Smith didn't... back to the Warren King thing. I'm going to get to the good part. On cross-examination, Smith denied receiving any deal or anything from the prosecution in exchange for testimony. ADA John Johnson, not Fred Head. This is John Johnson. This is a different person. Why are they saying sister? I don't know, man. It's law and crime chat. There's no telling. Oh my goodness. Looking at the law and crime chat, you know what it reminds me of? It reminds me of the time that I got banned from the legal advice subreddit because I kept disagreeing. Back when I would go on Reddit, because I kept disagreeing with the legal advice given by other people who clearly had no idea what they were talking about. And because I'm me, I had to like insult them as I did it. It's like it was a bunch of people that would just give terrible advice, and it was like they were cosplaying as lawyers because they wanted to sound like scary and authoritative. And they would always be like, "You're out of luck. You should have been smarter. You're stupid. You're screwed. There's nothing you can do because you're a bad person." And they'd just be completely wrong about everything. But they like thought they sounded authoritative. And I would just tell them they were stupid. And I imagine like the Venn diagram between the legal advice subreddit and the law and crime chat is a circle. A van from again. Free Orville Redenbacher. That's a weird one. Subsequent to King's trial and after King's sentence was upheld, Smith was allowed to plead guilty in exchange for a sentence of life with the possibility of parole. This was 25 years ago, by the way. So yeah, basically in the Warren King case, the co-defendant was allowed. He testified that he didn't have a deal, but it certainly seems that he did. Mr. King has since diligently sought evidence of a deal, and the state has continued to deny one existed. Yet now, more than 2 decades after his conviction and death sentence, Mr. King has discovered that Deputy ADA Johnson, John Johnson, not Fred Head, had in fact approached Mr. Smith's attorneys months before trial with a deal in exchange for his testimony against Warren King, and ultimately secured Mr. Smith's testimony against Mr. King with a promise of a life sentence to Walter Smith without parole. Johnson knew about his deal with Mr. Smith when he repeatedly denied the existence of a deal to defense counsel in the court when Mr. Smith testified under oath at trial that he had received nothing for his testimony, and when Johnson himself repeatedly told the jury that Mr. Smith had received no deal or promises during his closing arguments. Thus, the prosecutor not only suppressed material impeachment evidence, but then took further advantage. I just got another raid notification from Kat. Kat, did you just go live for the question? You're like a Viking. My goodness. Rating like crazy. She did? Okay. Oh, hey, Guyvermectin. What's up? I don't know if you were here before. Did I see your name earlier? I can't remember if that was this or a different stream. What did you guys think about the question? Was it good for Alicia or bad? Hey, everybody. I think good. Yeah, I think the same. Hard to tell, though. They could just be like asking, trying to figure out on background. They haven't even gotten to deliberating yet. We're back. You missed the part where the ADA was named, where are you? John Johnson. So we have a Fred Head and a John Johnson. There's actually a fun fact about the name John Johnson. When what's his face? Oh my goodness, what's his name? Guy Fawkes. We were hoping you wanted to explain. I mean, the bottom line is it's impossible to tell. I think it's good for the, probably good for the defense. It seems like they didn't find the element for first, if anything. They could just be getting background. Like maybe they didn't find the element present for first degree, and they were checking if the same thing would hold true for second degree. I thought it might be good. Yeah. Yeah, I think that's right, John. Yeah, I heard it the same way. But like I said, it's you know, they could just be confused and haven't even started deliberating yet. Just discussing the law first. Okay, so when Guy Fawkes was going to do the gunpowder plot, he assumed a fake identity to like get himself in with one of the royal families so he could get access to Parliament or something like that. But he was afraid that if he used his real name, he would be caught and detected, right? So he had to come up with a fake name that wasn't suspicious. And you know what nickname that he used that definitely wasn't an alias? He used John Johnson. That was the name that he used that nobody would be suspicious of. And it worked. John Johnson was a successful alias for Guy Fawkes in one of the most notorious terrorist assassination plots of the last 500 years. Which really makes the point. The point that you should take away from this is that it was extremely easy to scam people in the 1500s. Because you could just slap the name John Johnson on there and you're good to go. You didn't even have to come up with a good fake name. John Johnson. Guy almost blew up Parliament. That's the quality of the work they were doing back then. John Johnson. Not even like Chris Johnson or Stephen Johnson. Why do we use John Doe? I don't know. Oh my goodness. Harry Harrison. Yeah. Let me see. Where was I? There we go. Oh, this is a good bit. Jim McIntyre. I wonder where Jim McIntyre is. In addition, Mr. King has now obtained additional previously suppressed evidence that conclusively demonstrates Deputy ADA Johnson's discriminatory intent in jury selection against black and female jurors. Evidence that, again, counsel for Mr. King diligently sought unsuccessfully for decades throughout trial and post-conviction proceedings, which was not disclosed to Mr. King until recently. What if they convict on count 2 and on... Oh, man. That would be fantastic. Wait, which one is count 2? Do we have the indictment? I guess I could look it up, right? Because it's Florida. Man, I wish there was some kind of like video that said the judicial district in large letters across some kind of seal so that I could know which court to look up. If only there was some kind of word that I could use, being the smart person that I am, to find out which district court oh my goodness. This website, man. Use Dom Wiz sign. I should have been Dom Wiz for Halloween. I could have made a seal and put like Dom Wiz on myself. Or maybe just like the banner and wrap it around myself. That would have been good. I could only use that like in this stream and nowhere else, but there we go. Andrews. State of Florida versus Alicia Andrews file. There we go. Bruce Harvey next year. I don't want to do Judge Cannoni because people are going to take pictures of me on Twitter and be like, hey, is this Judge Cannoni in Los Angeles? Even though it's clearly just me with a wig on. That was one of my favorite Twitter trends, to be honest with you. The is this Judge Cannoni Twitter discussions. It was just like a random lady with like light blonde hair, older than 25 years old. And that was enough for a free Karen Reed Twitter discussion. Let me see. Summary? No. Charges, hearings, warrants, file location? Wait, which one is this? 2019... 29... Man, this is so much worse than the district Mally's case is in. Summary parties, events. People thought someone else in the Adelson... Okay, I don't know. I'm going to have to dig this up. I'm going to finish reading this. I'll probably call it a day. I got some errands I need to do tonight. Free Pee-wee, then lock him back up. This chat, I swear to God. Okay. Oh yeah, please hit the like button or Jim McIntyre is coming after you. True. All right. New evidence includes the prosecution's work product identifying the race and gender of all of the prospective jurors and reflecting the prosecutor's race consciousness throughout the voir dire process, repeated tallying of the number of black and female prospective jurors who are being accepted or struck from the jury, and distinctly disparate note-taking on the behaviors and answers of black qualified jurors as compared to white qualified jurors. Thank you, Trish. This recently discovered evidence was not available to Mr. King at the time of his trial, appeal, or in his initial habeas proceedings. All three of these claims undermine the fairness and reliability of Mr. King's capital proceedings and his resulting death sentence. On the basis of these new damning revelations, which establish the constitutional violations Mr. King has sought to prove for decades, this court should grant habeas relief. This is actually the rare case. The reason Kat and I were interested in this is that there are very... It's relatively rare for Batson challenges, which are Batson violations, which is when you strike jurors on the basis of race. It's very rare when they're found to have existed. But in this case, there actually was one. In Brunswick Circuit District Attorney's Office, by the way, is... If you were here at the very beginning of the stream, that's the same district attorney's office that was involved in this case, in the Friday night case. Now they've asked for somebody else, and the answer is no. It's 4:15, and I'm not going to go into more. They want Scott Harrell's testimony, too. I'm not doing it. I'm not opening it back up. They're just going to have to remember it. It's Friday afternoon. I'm not doing it. That is the same district, roughly 10 years earlier, that this happened in. But yeah, kind of, or maybe just me. I don't know if she still wants to do it, but we're going to go through this at some point. It's going to be Curtis Flowers, I bet. When these jurors sending my homegirl home, I helped her return ill I could. I don't know. We'll see. I can't imagine there'll be a verdict tonight, though. I mean, maybe, but I'd be surprised. "30 people in the bush." Oh, man. Just checking one thing real quick. If I was sure, I wouldn't come to a decision. Just be... Yeah, that thing about I'm noting that you're rude for the record seemed kind of over the top. I was not a fan of that. This case right here. We're going to be looking at this case at some point in the near future. Flowers versus Mississippi. I'll just read the little syllabus for you. Petitioner Curtis Flowers has been tried 6 separate times for the murder of 4 employees of a Mississippi furniture store. Flowers is black. 3 of the 4 victims were white. Defense attorney was reading all my not popular opinions. That's how I get all my tips. Flowers at the first 2 trials, the state uses peremptory strikes on all of the qualified black prospective jurors. In each case, the jury convicted Flowers and sentenced him to death, but the convictions were later reversed by the Mississippi Supreme Court based on prosecutorial misconduct. At the 3rd trial, the state used all of its 15 peremptory strikes against black prospective jurors. The jury convicted Flowers and sentenced him to death. The Mississippi Supreme Court reversed again, this time concluding that the state exercised its peremptory strikes on the basis of race in violation of Batson. The fourth and fifth trials ended in mistrials. So I'll just make a little note here. 1 and 2 is misconduct. 3 was Batson. 4 and 5 were mistrials. And then 6 was this case. So he has sat through 6 trials and 3 rounds of appeals. This would be the 4th round of appeals. At the 6th trial, the state exercised 6 peremptory strikes, 5 against black prospective jurors, allowing 1 black juror to be seated. Flowers again raised a Batson claim, but the trial court concluded the state had offered race-neutral reasons for each of the 5 peremptory strikes. Ever considered Quiet Mouse? Sorry about that. I did have to turn my gain up. I can probably fix that. And thank you. Jury convicted Flowers on Lipson death. The Mississippi Supreme Court affirmed. After this court vacated that judgment and remanded in light of Foster v. Chapman, the Mississippi Supreme Court again upheld his conviction in a divided 5-4 decision. Justice King dissented on the Batson issue and was joined by 2 other justices. Held. All the relevant facts and circumstances taken together established that the trial court at Flowers' 6th trial committed clear error in concluding that the state's peremptory strike of black prospective juror Carolyn Wright was not motivated in substantial part by discriminatory intent. Notice this opinion was by Brett Kavanaugh. Clarence Thomas was the one lone dissent. Gorsuch just dissented as to a few parts. Race-neutral reasons are both... Yeah, they often are. It's like really easy to come up with a some kind of facially neutral reason, even if it's not true. It's pretty easy to come up with any... You can pick like any excuse you want. But, yeah. This one's quite lengthy. And yeah, I'm going to do this one soon. After I get done reading the Law and Crime Chat. I hope we get through this, Bay, Alicia. I don't want to see you leave my side. I've been crying nonstop. We was close to purchasing our first home together. Remember, I bought you your first G-Wagon. Free Joe Exotic. This is such a cesspool. Oh my goodness. This guy's written that same copy pasta like 30 times. Oh, man. Hey, wait a minute. Today's the 1-day anniversary of the Young Thug guilty plea. It was Halloween 2024. It was actually my most engagement on Twitter for a long time was from October 31st, 2024, because I kind of said some stuff that I shouldn't have. About certain people on that day. If I say trick or treat, can you give me some Brian Steele? Of course. You don't have to say that because I'm already looking it up. Why is it so hard to find this? Here we go.
That I guess was being negotiated was
What?
some
Why aren't you making noise?
Until the state completed its case, and
Oh, it was
she
quiet.
The evidence has shown that the defendant
I don't want to listen to this.
himself, that your mammy, defendant William, not complete all
I
charged
don't want to
with
listen
the
to this
murder.
part. Okay, hold on. Let me find something better. Oh, now they're just putting up Moontung stuff because it wants to troll me right now. Why is it so hard to find the full part? Good lord. I guess I could just look up the date. It's just giving me Moontunk results now, even though I'm specifically searching for Young Thug. It thinks it knows me. It's just kind of... Oh, here we go.
Society.
More apparent as he rapped and talked about the crimes that YSL co-conspirators and members committed and how he got away with robberies. And to finish what Mr. Myrick could not complete, that is the killing of Mr. Bennett.
We have put before you. You also have, I believe, the paperwork that was given.
Part.
And
You know, I did.
This is maybe my favorite of all time. Whitaker W. It is not lost on the court that the state was willing to entirely dismiss the RICO count. I haven't listened to that part in a while. I haven't listened to that before. I can't quote it verbatim.
Free shows and gave it to single parents, millions of dollars. You know, I made $1.8 million since my and all that out.
I appreciate that you do realize how much of an impact you have on people. I mean, it's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living in and around that, you know that gangs are damaging to our community.
I haven't even watched all the way. I saw try.
And it may be
No,
that
please.
a whole lot of rap music and the rap industry is, I mean, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television, where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what is going on in the music industry with rap. But whether it is fake or not, it has tremendous impact on kids and young people who think, this is cool, this is what I want to do, look at him, he's a millionaire, I can do that by being, you know, a gangster in the streets. And that's not true. What you're likely to have happen to you if you're a gangster in the streets is you get shot, you get killed, or
You get charged with the wrong... I'm sorry, I'm not
thrown
going
in
to finish that
prison.
joke.
And those are, you know, by far the most likely outcomes. And, you know, you've been in here watching the trial, and you've seen the pictures of Mr. Ryan posing with a gun as big as he is at 15 years old.
Oh, wait, let me finish.
And going out and shooting and killing another teenager. And that's what gangs do, and that's unfortunately a lot of what rap music does. And if you are a modern day John Lennon, you know, I mean, he might have rapped too in this day and age.
John Lennon was not a good dude, by the way. Yeah. Also, the thing that's like kind of implicitly bothered me about this, I mean, I agree. Like, I get what she's. Actually, I don't really completely get what she's saying, but like, if Ryan was so immature, or I don't mean like immature behavior wise, but like not old, not experienced, immature. to the point that he was like that impacted by music and thought that everything was literally true. He's probably not mature enough to try as an adult, at least in my book. Like, if he's still that... Exactly, Kat. If he's so immature that he's like, oh my God, everything that any rapper says is true, I have to be like that. Like, you shouldn't be being tried as an adult. Like, come on.
No, but I know you're talented, and even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the powerful guy at the end of the street selling drugs. And, you know, I know that happens for protections.
You know, sometimes there isn't. The high school that that neighborhood feeds into, I know they didn't have a math teacher. They literally didn't have math as a class there. You know, it's not a... Nobody wants to be a gangster. I mean, like, kids do, but they're stupid. Kids are idiots. I think we all know this. I hope there are no kids watching this. If there are, you're one of the smart ones. But, like, nobody, like, wants to be... Nobody wants to sell coke. Okay, again, there are exceptions to that, but, like... Come on.
Sometimes, but a much better way would be getting an education and setting, you know, hanging around with people who set a good example. And you be one of those people that sets a good example. I mean, all right, so that's my high horse on that. I could also go on. But I want you to try to be more of the solution and less of the problem. All right? All right. So it is not
my favorite part.
Lost on the court that the state, had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, machine gun count. Was willing to give a sentence that permitted Mr. Williams to walk out of the door today, and therefore does not seem to be particularly worried that Mr. Williams, if on the streets, would be a danger to society. I'm taking that into consideration in crafting my sentence. And in permitting a nolo plea to the RICO count and one of the two gang counts, I would not be permitting the nolo to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts, and for the remaining counts with which you are charged, I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution.
It's my favorite part. One of my favorite parts.
And I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution. On count one, the court sentence is 20 years to serve 5 years, commuted to time served, the balance of 15 years to be probated, and a $25,000 fine. On count two, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count.
What happened to, I don't know,
It is
actually. I
required
was
to be
wondering
run
about that.
consecutively. I'm going to run it consecutive to count one, but I am going to backload. Oh, I'm sorry. That is not commuted. That is 5 years to serve, and it's going to be run consecutively to count one, backloaded, by which I mean after you serve your 15 years of probation, if you have been successful on that probation, and I sincerely hope that you are, then at the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence. But
All right. I'll show one last thing. This is the last thing I'm going to show. And then I got to call it a night. This is kind of on the theme of you were willing to do X. This is an order denying Antonio Sledge's bond. You can see that it's dated October 14th, 2022. And the reason he was denied bond are all of these. Defendant poses a significant risk of fleeing from the jurisdiction of the court or failing to appear. Significant threat or danger to any person, the community, or to any property. A significant risk of committing a felony pending trial. A significant risk of intimidating witnesses or otherwise obstructing the administration of justice. So, that was October. This is December. They actually started negotiate. The first communications on negotiation were in November. But just 2 months later, 15 years probation, and then this is no sentence at all. So on October 14th, they're afraid that he's going to not show up and intimidate witnesses and commit felonies and be a danger to the community, a significant threat or danger to a person, community, or property. 2 months later, they're willing to let him walk out the door. And not only that, there's not even a condition in the sentence. Yeah, it's really fast. There's not even a condition in the sentence that he refrain from contacting witnesses. Which you think you would want in there if you're afraid that he's going to witness tamper. But no, as soon as they got the guilty plea, they weren't worried about that anymore. It's kind of like how they would put conditions on sentences saying you can't talk to the other defendants, but there's nothing about not contacting victims, which is a more common condition to have. But yeah, he was allowed to contact witnesses, allowed to walk out the door. I know it's funny. So negotiations were on the 27th of December, right? But he was in prison on the 25th. So he was too much of a danger to society on December 25th. But on December 27th, he was fine to walk out the door. So really what we're talking about here is December 26th. The only reason he should have been in jail on December 25th, on Christmas, was if he experienced some kind of wildly rapid rehabilitation on December 26th. So I really want to find out someday what happened on December 26th that made it okay to release him into the world, whereas on Christmas he couldn't be. You know what I mean? It must have been an amazing day. There must have been all kinds of healing, self-reflection. In Rice Street of all places, there's a place where people notoriously experience, great therapeutic growth. Oh, that makes me crazy. I'm like a parody of myself at this point. I really need to stop. Okay. I'm gonna call it a night. I meant to go for like an hour or two. You guys kept showing up. Is this Alicia Andrews thing still going? It is still going. It's after 9 o'clock there. These comments, I swear to God. A Christmas miracle. His heart grew 3 sizes that day. Florida got no quitting. True. All right. I'm gonna call it a night. I got some stuff I gotta do. But thanks for tuning in. I'll be back soon. I'm not sure exactly when. Like and subscribe. Comment. 11 p.m. Really? Wow. I would not, like, I really just wouldn't want people saying, at least I'm, like, doing something, though, Matthew. They're just, like, staring at the seal. It looks like a person just pointing at an eagle. I'm not gonna do an analysis of the seal right now. Although I want to. Oh, really? Interesting. Yeah. I don't want people doing that. That's crazy. Oh, thanks. Thanks, Trey. Yeah, I'm going to call it a night. Have a good night, everybody. Have a happy Halloween. Watch out for poltergeists in your house. Yeah. Have a good night, everybody.